in 1991.
In
91.
Correct. In a diploma rather. Time. So I'm motivated by that, and I regard that as the only real knowledge that will count, because it counts for eternity.
Yeah. Well, still on that topic, before we get into your judicial career, you do a lot of work in that sphere. I'm not going to say is it charitable, mentally.
Yes, I ministry for some 50 years. He's 74 years old, and he's still not actually retired. He retired officially, but he's actually still working in missions and building churches and so forth. And we have a program in Kenya where we train people in theology, and that was the reason. We train pastors in theology, and that was the reason why I pursued the academic studies in theology, to be able to help. So we have a program in Kenya where we've trained 32 pastors from 2014. They graduated in 2019. It's done through a theological seminary in Cape Town. We now have another 40 students. So the a year for a prosecutor and then a magistrate.
All right. So you went back to practice, then got the Fulbright scholarship, and upon your return from Harvard, you joined the Cape Bar.
Correct.
How long were you there?
I was there for about 20 years. I joined in 1993 and finished in December 2012. So it's just about 20 years.
Did you take silk?
I took silk in 2004. I practiced half of my career at the bar as a silk.
All right. So you acted as a judge periodically between 1998 and 2011, according to your CV, your application form.
That's correct.
All right. I count 2, 4, 6. I count 8 acting stints.
That's correct.
Okay.
In fact, I should mention that when I made myself available in 2012, Judge Mogoeng was the Chief Justice at the time, said to me that he was younger than me, and why did I only make myself available for appointment in 2012? And my response was this. I'd been invited by the late Judge President Friedman in Cape Town to act in 1998. I was 5 years at the bar. I came away from that experience, and this is what I told the JSC at the time, that I was nowhere near ready for this job. And I just realized that this is a hard job.
Yeah,
I don't have the necessary skills and experience. I was trained and mentored by very senior judges and established judges like Judge Fritz Brandt, who you know ended up at the SCA, Judge Friedman, Judge Likovitz, who's now in Australia. But I came away with a distinct impression that I needed to, as it were, put simply, go through the ranks. I returned to the bar, and that's why I did those acting stints, and then took silk, and the rest is history.
Yeah. Well, you were lucky. Some of us didn't enjoy that luxury. I had been at the bar for 5 years when I was called to act in that very division, and I was not given a choice, and I stayed on, and the rest is history. So, in November 2016, you were, no, before that, yeah, in November 2016, you started acting at the SCA. Upon my invitation, I had heard very good things about you. I was looking, lounging around as heads of court usually do for acting judges, and someone mentioned you in the case, and you came to the court and you proved that person right. You did well, I must say.
Thank you.
So how long did you act at the SAA before your permanent appointment in 2018?
My first term in the SCA was the November term, and I never left because I acted from the 1st of November until my appointment on the 1st of June 2018.
Right. And you have also acted in this court to which you seek to be appointed for 2 terms, not so?
Correct. That was in August 20, or the August and the November term 2023.
How did you find that experience?
As I've indicated in the previous interview, the judges there work extremely hard. I'm not going to plow the furrow of the applications for leave to appeal. I think that has been done ad nauseam. So all I'll say is that the judges work extremely hard, but it is a very collegial environment, and particularly when you differ with colleagues, because in my very first term, as you are aware, I wrote a dissent, and the collegiality is to be commended at that court.
Yeah. I'm not going to ask you about the number of judgments you've written and all that. Your resume speaks for itself. You are one of those extremely hardworking judges, but by all accounts. The one thing I wanted to raise with you is your age. How old are you now? That tends to be an issue for a number of people.
Yes, I'm 67 years old at the moment, and I will turn 70. I can deal with this now.
Yeah,
I can
please.
turn 70 on the 19th of June, 2028, God willing. I should say that Appointment to the Constitutional Court.
Well, a very fit 67-year-old, I might say, do you still cycle and run and do all those
Yes,
things
I've done.
competitively?
Yes, I'm very active. That's what enables me to write the judgments that I do. You've got to have energy, and I've done 26 August tours, and on the 19th of October, I hope to run the Cape Town Marathon. But to get back to the topic as to my remaining tenure at the court, let me say at the outset that a candidate for the Constitutional Court should not be assessed according to the length of his remaining tenure, but rather the depth of his experience and the consistency of his commitment to the Constitution and its values. I don't have to go through my skills and experience. We've dealt with that. I believe that I will bring a broad and seasoned perspective to the Constitutional Court. I have an LLM in constitutional law. You would have seen from my questionnaire that I have been involved in landmark cases as counsel. I should mention that one case that is not in my questionnaire is the Richtersveld case. I did that case through the Land Claims Court. I argued the case alone against senior counsel in that matter. I won it in the Land Claims Court. I lost in the SCA and I lost in the Constitutional Court. I was led in the Constitutional Court. I had done all the work and drawn the heads of argument. I was led in the Constitutional Court by now retired Justice Madlanga. I was fortunate to have practical training in the United States. I worked at a law firm in Washington, D.C. called Fulbright and Jaworski. Leon Jaworski was the prosecutor in the Watergate scandal. I'm qualified to practice in New York. I've taken the New York bar.
A very tough bar, I'm told.
There are I'm told that the two toughest bars in the United States are New York and California.
Yeah.
So I can also say that my judgments demonstrate my skills and experience dealing with the question of my remaining tenure. In AfriForum, in the flag case, when AfriForum claimed that they were exercising their right to expression and culture, I saw it for what it was, hate speech. We cannot hark back with the symbol of apartheid and long for the white domination that relegated the majority of people in this country to second-class citizens. In the British American tobacco case, and that is which was decided after the COVID-19 period, I struck down the government's ban on the sale of cigarettes because a pandemic does not justify the irrational exercise of public power or the violation of the right to dignity or property, as happened in that case. This is not because I was sympathetic to tobacco companies, but the pandemic was not a license, as I've indicated, for the exercise of irrational public power. When Steinhoff refused to make available the PwC report in what is arguably the greatest corporate scandal in this country, I ordered its disclosure. Transparency yields to the public interest, particularly as regards the right to information when there's fraud. I should also mention that in the Steinhoff case, I changed a principle of law which provides that our law of evidence is English law. And that principle provides that if you give a document to an attorney, there are two kinds of legal professional privilege. The first is privilege relating to the conduct of litigation, and the second, legal advice privilege. And Steinhoff sought to rely on legal advice privilege and refused to disclose the report. I changed the law in this sense that once a party gives a document to an attorney, that document is privileged. However, the change came when I adopted the position that applies in first Australian law, English law, Canadian law, and New Zealand law, where it must be demonstrated that the dominant purpose of giving the report to the attorneys is for legal advice privilege. I found that it was not and ordered its disclosure. So what does it mean when I come to the tenure questions? You've been told, and you've probably heard, that there are many candidates who will probably have longer terms to serve than I would at the Constitutional Court. I offer, however, something rarer, I believe. A judge that's fully formed, no apprenticeship, no finding my feet, no cautious early deference to senior colleagues, no promises of development, no investment in potential. I've been 9 years at the SCA and I've written 98 appellate opinions. That comes to about 11 per year. These judgments draw on 3 decades of constitutional experience. I'd like to think that I've made all my mistakes, but obviously I will still continue to make mistakes. But what I have is that I've refined my reasoning. I've learned when to compromise. I've learned when to stand alone. I think the clearest example of this is the Vodacom case.
Yeah, you wrote the dissent in that matter.
Correct. And GB versus CB, which is also a dissent that I wrote in the Constitutional Court. And also C versus C, which dealt with gender-based violence in the SCA. So I don't see the Constitutional Court or the constitutional age gap as I see it rather as a safeguard. It's not a disqualification. It's a safeguard. It ensures periodic renewal of appointments and allows the CC to draw on focused late career expertise. I believe the CC doesn't need me for succession planning. Rather, I could contribute to surge capacity. I can make an immediate, substantial, and tested contribution when the work is overwhelming and the stakes are highest. I also believe that impact follows a readiness and clarity, not length of service or remaining tenure. I illustrate this with reference to Justice Mohammed, and I don't regard myself as anywhere near the stature of those judges, let me add. But Justice Ismail Mohammed wrote Azapo and Fraser within 2 years of his appointment, and those decisions still anchor our jurisprudence today. Justice President Chaskelson wrote Makwanyani, in his first year of service. So my method, Chief Justice, is simple. High quality output, consensus where this is possible, and principle dissents where it is not. So let me say in conclusion on this point that I do not see my remaining tenure as a limitation, but rather a strategic advantage. I don't need time to find my feet or learn the institution. And in this regard, allow me to, I think the position is best stated. I can do no better than quote you what the advocates for transformation have said as regards my candidacy for the Constitutional Court. Paragraph 5.1. The reviewer's opinion is that the candidate has shown the ability to balance divergent legal opinions and seek common ground among colleagues on the bench. A number of the judgment authored by the candidate in his application represented the unanimous opinions of the Supreme Court of Appeal. Even in cases where the candidate expressed a minority opinion of the Supreme Court of Appeal, in every case, he was joined by other justices of the Supreme Court of Appeal or the Constitutional Court. In all cases, the candidate's judgment reflects clarity, careful reasoning, and a willingness to engage with competing views in a manner that narrows disagreement rather than deepens it. As an appellate judge, the candidate's role in multi-judge panels has consistently required collaborative engagement. The absence of dissents authored against his judgments at the SCA in certain high-profile matters suggests that he is often able to bring colleagues together around a principled outcome. What remains is for me to say, I'd be honored to serve at that court.
Thank you, Justice Keepers. Do you have questions for this candidate, colleagues? Professor Marumakai?
Thank you very much, CJ. Good morning, Justice Keepers.
Good morning, Professor.
I'm always encouraged when I read your judgment, particularly those where you dissent. I'm not a fan of unanimous judgment, and I understand that there is this view that you must have the ability to bring colleagues together on a common. I understand that, but I think there is absolute value in dissenting judgments in the appellate courts because they provide a sense that we don't have one judge in the court. We have people who think differently, and that strengthens the jurisprudence. And I think I need to commend you on your ability to do that, both at the Supreme Court of Appeal and at the Constitutional Court.
Thank you.
There is one judgment at the Constitutional Court where you did exactly that. It is that matter of DB versus CB. That particular matter traveled all the way from the Magistrate Court all the way to the Constitutional Court.
Correct.
And when I read all the judgments that are written in this matter, I thought initially that there is not much of a difference between an ante-nuptial contract and a pre-nuptial contract. In other words, one would see it as sort of synonymous, I beg your pardon. But it appears from this judgment that all the judgment that they are actually not, because in this matter, you found that there was an ante-nuptial contract signed and there was a pre-nuptial contract signed. Yes. And the difference perhaps it might be one might have been notarized and the other might not have been.
Yes.
So my question to you is, in the case where there are these two documents and the pre-nuptial contract deals with the issue of spousal maintenance.
Yes.
How does that affect the discretion that the court should have in terms of Section 7 of the Divorce Act?
Yes, thank you, Professor. I think that's an important question. Can I make one point in answering you firstly? And that is, I've said it before, and I'll say it again. Being a judge is a hard job. You've got to see Your judgments have consequences, and you've got to see what is coming down the road, as it were. And in that case, the problem was, and interestingly, it was not a point that was taken, if you read the judgment, it was not a point that was taken, it was one of the points that was taken by the parties, but importantly, where the contract, the deed of, what the so-called deed of donation, I found that it was not a deed of donation, and the reason for that was that it dealt with spousal maintenance for the rest of your life. It dealt with a car. It dealt with a home. It dealt with medical aid, all spousal obligations. That was not a deed of donation. It was, as I saw it, simply an agreement to provide for spousal maintenance and the like, and it cut across, as you correctly point out, the court's powers under Section 7 of the Divorce Act to determine, as at the date of the divorce, whether a spouse is entitled to maintenance. Here's the danger. You could have a young man enter into a deed of donation with an elderly woman and take her for everything she's got, clean her out completely, then get married, because remember, it's a prenuptial agreement, and a week later, enforce that deed of donation. That's why I say you've got to go look what's coming down the road. And that is why I said a donation is, as the name indicates, something that you do gratuitously. It's based on pure benevolence. Here, there was no pure benevolence, and what happened was they cut across the court's powers when the divorce came to determine whether that spouse was entitled to maintenance and also whether the spouse's financial position at that point in time, i.e., at the date of divorce, was justified, or rather justified, the giving of maintenance.
Thank you very much, Judge Skepas. And what is important to note here, and this shows the value of dissenting judgment, is that even the CJ and the deputy CJ at the time, they agreed with your approach, and your approach was absolutely correct, actually.
Yes, thank you, Professor. You're quite correct. The CJ, the CJ at the time and the current CJ concurred in that judgment.
My second question to you is in relation to the empowerment of junior advocates, particularly black female advocates. And we have the honor of watching most of the constitutional court cases on YouTube. And often when one is watching those proceedings, it seems to me that we are not in South Africa. The bench is generally black, but we see that the bar is increasingly becoming white, where we see white males and some few black white females and selected black senior counsels are appearing before that court. And we don't see black females in particular appearing in that court. And I understand that it's not the courts that are briefing advocates. And one cannot really put a blame on the judges because they're not the ones who are seeking out and determining the briefing patterns.
Yes.
What is your view? Is this normal in a state like South Africa, where we continue to see white males flourishing in practice and being dominant in the cases that are presented in at least the Constitutional Court? Is this something that is normal? Is there something that we can do about this?
No, Professor, it's not normal, and it's particularly not normal given that we're already 30 years into this democracy. I had a policy of working, as I've said in my questionnaire, virtually exclusively with black counsel. In fact, when we did the Grootboom case, Ms. Nazrin Bawa was my junior, and and she's taken silk today. Mr. Tabani Masuku was also my junior in many cases. He's also a silk today. So I had a policy of mentoring junior advocates, and unless the approach changes in boardrooms, particularly, we were able to do this because we got work from the state attorney. I worked for a firm that briefed me once, so-called white firm, briefed me once in my 20 years at the bar. And I think my reputation and the cases I've done spoke for themselves. But it just doesn't happen. And I think there must be a different mindset in boardrooms, and there must be a conscious attempt by senior advocates to engage the services of particularly black women advocates.
So sorry, CJ, if I can just follow up on this. I guess my question is, what can the judges do? Because this pattern of representation appears before the judges. We know recently that Judge Mota did something that for me was quite commendable, where he was able to ask us to, in a BEE matter, to say, but why are you dealing with a BEE matter and there is not even a single black person who is arguing before me? So that we don't isolate Judge Mota. We know, we accept that what he did, at least from where I'm standing, that it was correct. What can judges do to deal with this issue or to influence the process? Is there anything that can be done?
I think, speaking for myself, at an appellate court, and both at the High Court, you always have counsel coming to introduce themselves before the court starts. There's no reason why, and I've done this, where you cannot put it to the counsel. I noticed that I've looked at the heads of argument. I see that this case has got no women advocates. It's got no advocates of color. It's got no black women. Is there a reason for this? And leave it there. I understand that there's a practice in England, for example, where Lord Reed had stated that, had asked in relation to junior counsel who do not argue, and they participate in the case. And he's issued a directive to say that junior counsel should, in fact, argue a part of the case, because the tendency is now not to, in fact, hear junior counsel. But again, it's not really something with teeth, because what he talks about is that consideration has been given to junior counsel to argue a case. By a parity of reasoning, I can't see why that cannot be done in the context of our courts.
Thank you, Justice Skippers. Thank you, CJ.
Thank you, Prof. President Mulemer.
Good morning, Justice Skippers.
Good morning, President Molamela.
How are you?
I'm well, thank you. How are you?
I'm well, thank you very much. The Chief Justice went through your CV. Oh, sorry. The Chief Justice has already gone through your CV. One aspect that did not come out, which I deem important to mention, is that you also acted as the acting deputy president of the SCA.
I owe you an apology, President Molamela. I've got a note here to say that I should have corrected that. I was never the act. I don't know where they got that information from. I've got a note that I should, in fact, have corrected that at the outset, and I clean forgot. It's not correct that I acted as the deputy chief. I never served as a DJP in the Western Cape.
No, I'm talking about the SCA. You're mistaken.
Oh, I'm so sorry. I'm so sorry. You're quite correct.
You had occasion to act
correct.
as the acting deputy president.
I'm sorry, I misunderstood you. Yeah, that's quite correct.
Yes, thank you. And you are one of the presiders at the Supreme Court of Appeal, and you have been a presider for a number of years.
That's correct.
Yes. Now, Section 174 of the Constitution is the one that deals with the appointment of judges, and amongst other things, it refers to the competence of people that should be appointed, and also alludes to diversity in terms of race and gender, amongst other things. Do you think it is essential to have a diverse bench? And I encompass all areas of diversity, including diversity of expertise. Do you think that it is important for the bench to have diverse areas of expertise? In other words, a diverse skills base.
Yes, absolutely. And that has been the position, particularly at the SCA. I've never done, for example, a case on trademarks and shipping law in practice, but I did it at the SCA.
I do remember that when you had occasion to be allocated a shipping judgment, and I think the Chief Justice was the presider in the matter at the time. I happened to be in the same panel as well. You co-authored the judgment with Justice Wallace.
That's correct.
Yes, who had broad expertise in maritime law.
Yes, he's got a doctorate in maritime law.
Yes. How did you find the experience of co-writing a judgment?
Well, it was a learning experience, and we divided up the work equally. And I was able to write my part, and he did his part. And I learned much about it, about shipping law, and then subsequently I got a case which was not similar, but in the same area, and I was able to do it far more easily than I otherwise would have. I should also point out that I do the same when it comes to the SCA. There's the case of, I think it was State versus Dabete in the Free State, where it was one of the first cases that was going to be prosecuted pursuant to the Zondo Commission, and all the accused were acquitted. And the case came to the SCA, and we had to decide whether there was a question of law and whether the question of law should be reserved in favor of the state, and whether the matter should be returned for the accused to be retried. I designated the scribe in that case, but soon discovered, after going through the documents, that the case was extremely complex, and then decided to co-author the judgment. And that is what we did, and Acting Justice Norman and I co-authored the judgment and made an order that these accused be retried in the Free State.
Thank you. My second question, CJ. The provisions of Section 167 of the Constitution in relation to the general jurisdiction of the Constitutional Court. As you know, the section provides that the Constitutional Court has jurisdiction in relation to matters that raise an arguable point of law or general public importance. I came across a document, and in that document, the author listed what the author thought were some of the factors that come into play when determining whether a matter is of public, raises an arguable point of law of public importance. And the three that were mentioned are as follows: where there is a minority view in the Supreme Court of Appeal, and the minority view is forceful; where there are different divisions of the High Court that have expressed divergent views on the matter with no pronouncement by the SCA, or where the SCA may have expressed itself on the matter by a narrow majority. Would you agree with these as some of the factors that should be taken into account?
Yes, that is a provision that gives
the court doesn't give the court jurisdiction. I think you're referring specifically to the article by Mr. Eshet Cohen. And as he argues in that case, and in fact, as was found in the Paulson versus Slipknot case, the issue is not so much jurisdiction as it is granting leave to appeal. And there are really three requirements. It must be an arguable point of law in the sense that it must have some prospect of success. Secondly, it must be a point of public importance, which goes beyond the specific litigants, but it doesn't involve a large section of the public. And thirdly, it must be one where the court ought to grant leave to appeal if it's in the interest of justice. And the question put to me by Professor, the Commissioner, this was exactly a 1673, because it dealt with an arguable point of law which deals with whether or not a deed of donation is enforceable. A deed of donation concluded before marriage is enforceable post the marriage.
Thank you, Justice Skeppers. Thank you, Chief Justice.
Thank you, President. Commissioner Pillay.
Thank you, Chief Justice. Good morning, Justice Skeppers.
Good morning, Commissioner.
Justice Skeppers, you've obviously read the Vodacom judgment by the Constitutional Court.
Yes.
And you would have seen that the new ground of appeal which the court upheld, which is the failure in the duty of proper consideration.
Correct.
So if one had to look at it as a litigant, it obviously opens up all sorts of exciting prospects of how you can tear judgment of a lower court apart and raise it as a ground of appeal on the basis of a violation of Section 34. And to your mind, where do you draw the line in terms of how bad must the assessment of a lower court be before it can constitute a failure of the duty of proper consideration?
That's a very important question, Commissioner, because the court and the Constitutional Court said it will only be a failure to properly consider the case will only apply in highly exceptional circumstances. And to use the words of Justice Madlanga, this is not open sesame. But I'm afraid it is, because we've already received, as you know, we received numerous applications for leave to appeal. And the first ground of appeal is the court failed to properly consider the facts and circumstances of the issues that were before it, and therefore our Section 34 rights were infringed, and therefore we should be granted leave to appeal. So we'll have to wait and see, but from what I've seen from petitions that I've already considered, I think probably about a week or two after the judgment was handed down, we started getting this new ground of appeal.
The other impact of the Vodacom judgment is that it brings to the fore again the age-old debate of whether or not a state litigant can invoke the right under Section 34 of the Constitution. Do you have any thoughts on that?
Sorry, I missed the point. Whether
a state litigant can invoke the rights under Section 34.
Well, if in the exceptional circumstances of Vodacom, and one must say that the judgment in Vodacom, particularly, and I'm talking obviously about the majority judgment, one can express it no better than that the Constitutional Court found that the majority had got it so wrong that there was a violation of the Section 34 right and there was a failure to properly consider. And to answer your question, a state litigant could invoke that provision because if, of course, the circumstances are such that justify the standard of exceptional or extraordinary as set out in Vodacom.
Thank you. Just a second topic, Chief Justice. Justice Kippers, you've seen the sexual harassment policy that's been adopted by the judiciary.
Yes.
In your view, what are the obstacles to implementation of the policy?
I don't see any obstacle to the implementation of the policy. In fact, when looking at the policy, I thought that one of its aspects that sitting judges should receive training, and it is an online training procedure for sitting justice to receive, is particularly noble, because especially the older judges, like my colleagues and my contemporaries, they are averse to going to training programs like diversity and so forth. And I think it's a good thing, it's overdue, and it should be implemented.
Thank you, Chief Justice.
Is it me, Chief Justice? Or?
Yes.
Oh, thank you. All right. Justice Skeppers, good morning.
Good morning, Mr. Nkatobe.
Yes, good to see you again in that same position for the same job. I've been asking candidates about the crisis of inequality and I would say the paradox of a constitution that promises to end poverty and inequality, but at the same time it is producing poverty and inequality. Yes. And asking whether or not there's anything that in the structure of the constitution can be done better and differently by the judges in the interpretation of the constitution. So one of the ways of thinking about it is, well, perhaps there is an implicit right to economic equality in the constitution, but that it has not been recognized by the judges and applied. And a different variation of the same point was made by Commissioner Hassan yesterday, who says that the youth is disillusioned about the constitutional project because the constitutional project has failed to end poverty and end inequality. So I wonder if you have any ideas about this. My own difficulty, I moved from optimism to pessimism. I'm currently in the pessimistic phase about the potential of the constitutional project. So I wonder if you have any views on this, given that you are now, hopefully we can recommend it to the Constitutional Court, and whether there's anything we can do to break the logjam. There are just too many poor people in this country.
Yes. Thank you, Mr. Nkatobe. It's a highly relevant question, and I'm afraid that your pessimism will have to be endured longer because of two things. If there is an economic right to equality, that right will have to be defined. And it's difficult to give content to a right to economic equality, particularly if it's not in the Constitution. And I take your point that it is concerning because particularly the socioeconomic rights are not being realized. But you will appreciate that the Constitutional Court has been very careful in not only defining those rights, but also determining what the state's obligation is in relation thereto. And here I refer specifically to Grootboom and to DAC and to Mazibuko. You will be familiar with those cases. And there the Constitutional Court has said that these rights are, that when the state must give effect to these rights and relying on the International Covenant of Social and Economic Rights, that the steps they take must be reasonable. So at best for litigants is that they can bring an application because those rights are justiciable, there's no question about it. But what the court has said there is that there must be, the steps must be taken, the steps that are taken must be reasonable And of course, these rights have their internal limitations.
But what the court has constantly said is that the achievement of any particular social and economic right is in the province of the other two arms of government. And that's the unfortunate reality. But that doesn't preclude an applicant or applicants from approaching the court and saying, well, this court is, this particular government department has not done what you've said should happen in Grootboom. And the court in Grootboom said that what should happen is that when it comes to the allocation of resources, or where there's a deliberate withholding of resources, the state must give an account. And the state must also show, apart from policies that give effect to the right, whether or not the progressive realization, whether there are steps in place to continuously achieve the progressive realization. So I think that is the best answer I can give to your dilemma.
Yes, I wonder whether, I appreciate your answer and thank you for it. But that answer applies in the public sphere. It still treats the Constitution as an instrument that regulates the public sphere. But the economy resides in the private sphere. And the question is whether there is anything that the Constitution contemplates for the private sphere. The usurpation of land of African people is in the hands of white people today. Yeah. And there is a section in the Constitution, Section 25, that says the state should expropriate property, because property is the defining feature of inequality. But the state is not doing it. And the judges are also reluctant to force the state to do it. And this is why I'm saying I am in the phase of pessimism right now, that actually perhaps the constitutional project was not designed to end inequality.
Yeah. Yes, no, I appreciate that, Commissioner Kaitobi. The Constitution does, of course, have horizontal application in relation to private persons, but then, of course, you have to meet the equality requirements under Section 9. But one can also appreciate why this is best dealt with at the legislative level. I don't want to express any view on the amendment to the Constitution to provide for expropriation without compensation. But it's perfectly, all I will say is that it is perfectly understandable, because we know that in this country, without legislative intervention, the constitutional ideals are simply not achieved. This is illustrated by the Employment Equity Act, and even a simple, not a simple, but actually quite an effective piece of legislation like the Consumer Protection Act.
Thank you, Judge.
Thank you, Mr. Nakatobi.
Thank you very much, CJ. I'd like to do a follow-up on this issue. Thank you very much. Good morning, Judge Shepard.
Good morning, Minister.
I'd like to do a follow-up on the issue that has been raised by Advocate Commissioner Ngatobi, on the issues around the promises and what judgments would make and expectations of society. Let's take the Grootboom case, which has been one of the lauded as landmark cases that would have transformed the policy space in terms of human settlements in the country. Following that judgment, it would have been development of policy and, to a certain extent, I can say a promise, because there's this right, inherent rights that South Africans would have in terms of access to housing and shelter. But the reality is that in terms of the affordability of the state to be able to provide such service to majority of South Africans based on available resources and the economic constraint, it becomes practically impossible to do that. And the issue then leads to this despondency because there's a promise of the Constitution, there's a judgment that says the state shall provide based on that, and therefore the reality of the state's inability to be able to do because of the constraints that exist. Now, the question I want to raise, and I'm trying to understand from your side, is that how can we utilize that to balance? Because I think Advocate Ngwatubi might have moved to the issue of land, but the reality is that in all these spaces, as we do this judgment, do we think that there is a responsibility for us to find a balance so that we contain, or I'm trying to use the correct word, we allow for sustainability of our democracy, because continuously, if a promise remains on paper, but is not realized, that's what we see as despondency from the public.
Yes, unfortunately, the harsh reality is that the Constitutional Court has said that it falls on the executive and legislative arms of government to give effect to these rights because of their internal limitations. And the problem that you have, Minister, also is one of polycentricity. In other words, do you take money from healthcare and apply it to housing? Or do you take money from education and apply it to healthcare and so forth? And so the real problem is budgets and the fact that you have finite resources. But as I've indicated, that does not stop parties from enforcing the socioeconomic rights, and let the government then explain what steps they are taking and how they are progressively achieving the rights. I think that's the best you can do.
Thank you.
Can I make a follow-up?
All right. Commissioner Muimang?
Thank you, Sue. Mine will be from a different angle, but building on the issue of pessimism around the constitutional project. Let me first express my criticism to you, Judge Skippers. The judgment that you refer to as Calabrini versus versus the center of Cape Town. I find it a bit difficult to appreciate it, because the sense that one gets is that the right as enshrined in the Constitution is no longer now meant to be enjoyed by South Africans.
Sorry, I can't hear you, Commissioner. Can you speak a bit louder, please?
Yes, the point that I'm raising is that emanating from this judgment, the sense that I get is that now the rights as enshrined in the Bill of Rights are no longer now the meant to be enjoyed by the South African. You are now, the judgment now extend the scope to asylum seekers.
Yes.
It's more concerned about the right to dignity of the asylum seekers, and there is a crisis in our country of illegal immigrants.
Yes.
And now, just on the face of this judgment, one gets a sense that now this constitutional project, which is celebrated, is now meant not only for us South Africans, but now for asylum seekers. This is important because we have seen even how people that might have ran away from Eastern Europe,
yes,
and committing crimes in our country, use the same constitutional right to evade being sent back to their country.
Yes, thank you, Commissioner. It's a valid question. What was Scalabrini about? Scalabrini involved the rights of asylum seekers to apply for asylum. South Africa is a signatory to the United Nations Convention on Refugees, the UNHCR, I forget what it all stands for, and that provision it's called the non-return provision. It means that you cannot send an asylum seeker back to his or her country from which they have fled if they're going to be exposed to persecution on account of their religious or political beliefs or even death. What happened in that case was that the department, or rather the relevant act, the Refugees Act, was amended to say that if you don't come and appear before at the refugee reception office within a month after your permit has expired, then you will lose you're deemed to abandon your right to asylum, your application for asylum. The problem was that in reality, we know that the refugee reception officers are overwhelmed. The other reality you would have seen in the judgment, it's going to take 68 years to address rather the backlogs in the system in terms of all these levels of appeals. The non-return or non-refoulement principle is one enshrined in international law and is in fact entrenched in Section 2 of the Refugees Act. So what the Constitutional Court has consistently held in cases like Ruta is that you cannot return a refugee to his or her country from which he has fled without considering the application. So an automatic disqualification because you don't show up at the refugee reception office means that they don't consider your application, which would be unconstitutional and at odds with Section 2 of the Act. That is why the decision came down the way it did. And it's a valid question that you raise, and there is, of course, a concern. Unfortunately, we have this problem. We have a very expensive refugee system, and unless that's going to be amended and streamlined, we're going to continue to have this problem. And you would have seen also internationally, it's not our problem alone. This is what happens all over the world.
And luckily for you, you sit in parliament, you are a lawmaker. So
Thanks, CJ. Thanks, Justice.
all right, Justice Keepers, we've reached the end of your interview. Thank you for coming here this morning and sharing your thoughts with us, and all the best.
Thank you, Chief Justice, and thank you, Commissioners.
Please clear the room for deliberations, Secretariat.
your example, or rather the SCA cannot do what you are suggesting it should.
Thank you. Commissioner Mangan?
Thank you, Chief Justice. Good afternoon, Justice.
Good afternoon, Commissioner.
I wanted to ask you a question with regard to Section 17.2F that deals with reconsiderations.
Yes.
In the period that you have been at the SCA, did you get a sense that that procedure, that process, is being abused by practitioners? Because my assessment, it's not based on anything, but just out of reading of judgments. The president does give an order of reconsideration, but in the majority of cases, at least those that I've read, the judgments, more often than not, returns verdict of dismissal, suggesting that there is a bit of judicial irritation with that procedure. Is my assessment correct?
Commissioner, I'm sure you would have seen lately there are quite a number of judgments from the SCA dealing with that section. It's something that judges battle with, and speaking for myself, I hope that the latest judgment on it, albeit the court was split 4-1, I hope the majority judgment in that case will be the law, and we will stick to the law. To answer your question, I do not think that, well, let's start with lawyers, attorneys, and advocates. I do not think that they abuse the section. When I was asked earlier, we have a litigant who lost, who believes that his case was not properly dealt with, and he wants to seek further recourse. And the law is there. That remedy is there for that person. And I do not believe that we should close the door for that person. Because if leave is granted, the court will decide whether there are prospects of success, and if so, decide the merits of the case. So that is, I think, what the professor had in mind. Well, if not, then it goes to some way to answering his question.
Thank you, Chief Justice.
Commissioner Kwotsang?
Thank you, Chief Justice. Good afternoon, Judge Bloom.
Good afternoon, Commissioner.
Judge, I'd like to ask whether you have experienced discrimination on the basis of race in your career and perhaps on the bench and your acting stints?
Yes.
And if so, how did those comments by AFT make you feel? How did you respond to it at first?
Well, to answer your last question, I had a big laugh when I was described as a white male. And you will see then it says, that's, I think, 6.1, 6.2 says his nomination or his appointment will increase the number of female white judges. So let me just explain to you, if you're asking me, I have shared with you my experience in Makanda. That is, I was discriminated against because of my color. There's no other explanation therefore. In practice, the legal advisor of the Department of Education once called me and asked me whether I could assist in that matter. In a matter, I said, send the brief, let me have a look at it. And approximately 6 weeks thereafter, he phoned me and he asked, "Hey, what's happening with the matter?" I asked, "What matter are you talking about?" And that matter was given to a person belonging to a different race. And it hurt. It hurt because that person was my junior by far. And this person, the legal advisor, said to me, I was not Silk at the time. We do not want to appoint Silk, but we want a senior junior. And we thought of you. And I was discriminated against because of. On the bench, I cannot think of a time that I was discriminated against because of my color. Sorry, I'm not sure. I thought there was another question you asked.
No, it was just if you had experienced discrimination based on your race, how did the comments make you react or feel?
I had a laugh. I didn't take it. It's my organization, so I knew what's happening there. Thank you.
Sorry, Chief Justice, can I follow up? What do you mean you knew? You don't have to answer.
Thank you.
Justice Blom, there are no more questions for you.
Chief Justice, thank you very much. Commissioner, thank you very much.
Thank you for making yourself available.
Thank you.
Go well.
Thank you.
Are we going to take lunch?
or something similar to what you have as a law clerk in the Constitutional Court. What it entailed is doing legal research for judges, doing some administrative work, writing memos for judgments, ensuring that files are ready for judges, and doing some secretarial work for them. It was in the early days of the labor court, so the staff was very scarce. We, additional to doing that, did ushers work, basically taking judges into court, and we also made tea for judges, amongst other things. Good training.
Did you not clerk at the Constitutional Court at some stage?
Sorry, I missed that.
Did you clerk at the Constitutional Court at some stage, or am I mistaking you? For
No, I
else?
never did.
No, okay. So did you work just for one judge at the labor court, or for all the judges there?
I initially worked with the former Chief Justice. He then left and I think became a judge in the High Court in Pretoria at the time. And I was working with the acting judges in the labor court. He returned and I continued to work with him. I left the labor court, I left Johannesburg because I wanted to return back to studying, and then I returned to Durban, where I worked with all of the other judges. So I was based in Durban, and all the judges coming to Durban I would work with.
Which former Chief Justice was that?
Former Chief Justice Zondo.
Oh, that's why I thought you had once been a law clerk. Okay. Then you did your articles and joined the sidebar.
Yes.
Starting at Anand Nepal Attorneys. Where was that, in Durban?
It was in Durban.
Okay. You were there for 4 years, then did you form a partnership with them?
Yes, I did form a partnership initially. We were in partnership 2003 to 2007. And then I went on my own.
All right. You must have done pretty well there for them, not just to offer you a partnership, but to change the name.
I would like to
yours
believe
ahead.
that I came with some very good experience from the Judges Associate job that I had in the labor court. And because of that, the experience that I gained in the labor court, it has instilled in me, I think, what you would see. I don't know if it is on my application form, but it's on my CV, the thing about me mentoring students and law graduates, because I felt that the exposure and experience that I had doing that job is something that if I could, I would wish every law student to have when they completed their degrees. So when in practice, I tried to do that through having candidate attorneys, mostly female candidate attorneys, and for a good reason.
And what reason would that be?
What I had observed was, at the time, which seems to still be the case, at university during graduation, you see a lot of females graduating in the Faculty of Law. But in practice, the numbers start going down. And what I've observed even now in our court is you struggle to get acting judges, female acting judges, to come in, which says that they disappear somewhere along the way. So with the mentoring that I try to do is to encourage and empower females. I have female advocates that I'm mentoring. I have attorneys. I have law students that I'm mentoring through SAJE. Through SAJE, I'm mentoring potential judges, and then I have through SEC-IAWJ law students.
The Women Judges Association.
Sorry?
The Women Judges Association, we mean?
Yes,
by,
the
by
Women
SAC
Judges.
IWJ.
Yes,
Other
SAC
people may not know
IWJ,
what that
yes,
is.
the Women Judges Association.
Yeah. All right. Good. From May 2004 until June 2016, when you became you got an acting appointment. Well, we'll get to that. But during that time span, you built your practice and even practiced in your own for your own account. You left the partnership and struck it off on your own, alone. Not so. You ran Masipa Incorporated at some stage.
From
before-
2007, yes,
Yes.
up until I got appointed.
Uh-huh. And in between, you did a lot of work in quasi-judicial roles as a commissioner at the CCMA and numerous bargaining councils. What did you do there? Were you an arbitrator?
Yes, I was, I was a commissioner and arbitrator because at the CCMA, for instance, you have commissioners conciliating disputes and several other bargaining councils. And then you have an arbitrator who is going to be sitting in an arbitration, arbitrating disputes. So I trained for both and I was performing both.
Right. And you were also sitting as an assessor in court proceedings.
Yes, I don't know if it's ambition or it's an issue of empowerment as well. I did most things that opportunity presented, and in between that, having to raise my children as a single parent and concentrate on the law practice itself.
Nothing wrong at all with having ambition. Otherwise, none of us would be where we are if we didn't have a little bit of that. So your judicial career started in 2013. You acted between 2013 and 2016.
In 2013, sorry, I actually did pro bono acting in the labor court. Yes. And it was from that I got invited to come and act in the High Court. I was called and I was told they had read my judgments and they felt that they needed someone like me, and if I was willing to make myself available, then I could come. So then I made myself available. I started acting in the High Court in 2015.
And you were permanently appointed in 2016?
Yes.
In the case at N Division?
Yes, that's correct.
And you have acted at the Competition Appeal Court as well?
Pardon, I'm
sorry, Competition Appeal Court?
Yes, this is my third year.
Since 2022?
This is my third year in the Competition Appeals Court.
All right. And you've also had a few acting stints at the SCA starting in 2022?
Yes, yes, I've sat on during, I think, 5 sessions.
Yeah,
in the
June to September 2020. Well, yes. June, two last terms in 2022.
Yes.
And the second and third terms in 2023.
Yes, correct.
And 1 term last year.
Yes, that's correct.
All right. How long have you been at the Competition Appeal Court? Since January 2022.
How long have I been
at the Competition Appeal Court?
I said this was my third year. Yes.
All right. It's an ongoing appointment?
No, it's a renewable appointment. So it starts in the beginning of the year and it's been renewed every year at the end of the year.
Okay. Have you had a chance to write judgments in that court?
I wrote a judgment, I think, last month. Yes.
So only one?
only one that I wrote, and I wrote it alone. It was something similar to Section 18, is it 18.1 or 18.4 application where there's an appeal. There's a pending appeal, but then the rules there operate differently from the High Court rules. So when in the High Court, the filing of an appeal suspends the application of a judgment, it goes the other way in the Competition Appeals Court. The filing of an appeal does not automatically stop the judgment. So they had to bring an application to suspend the operation of that judgment. That is the one that I had to deal with.
I get the sense that maybe not many judgments come out of the court, but we had another candidate yesterday who had acted there and had not had a chance to write a judgment at all. And that was not my first encounter of people who have sat in the court and did not write. How does it work? Is there a fair allocation of judgment rights?
It's because there's not a lot of cases. So in the first year of my appointment, we actually never sat because the one case that I was supposed to have sat in was removed. Then there was no other case. Then in the second year, I sat in one case in the whole year. The problem is that because of the fact that we obviously judges of other courts, what would happen is that the president of that court would indicate to the president of our court to say, I need a judge to sit in one of the matters. Then the president I know on several occasions, our president would say, that judge is on circuit. And when they're on circuit, I cannot release them because it's going to create a problem. It's easier for somebody who, for instance, is during that session on the civil court role to get an acting judge for a week because they would take you out for a week and then they would then assist. So when most of the times that requests came for me, I was on circuit, so I could not be available. Then I think this year I've sat in 2 matters, which, excluding the one that I've just mentioned, which were written by 2 other senior colleagues. Yes.
So it is not a case of having just one person hogging judgment writing to themselves, as we have heard in the past about the court.
No, I don't think so, because it's not always the same people sitting. I've actually never sat with the same team at any given point in time.
Okay. You have written judgments at the SCA?
No, not in the SCA.
You have not written at the SCA?
Oh, you mean writing? Me writing?
Yes.
Oh, okay. No, I thought you meant judges pulling matters, important matters for themselves. No. I have. I've written 4 judgments in the SCA. Of those 4, one of them was a dissenting judgment. When I'm saying 4, I mean the ones that I wrote on my own. And then there were 2 judgments which were co-written with the president of the court. And those judgments were from the beginning allocated to 2 scribes. I think you understand how the process works.
Yeah.
So I had no choice of me writing that one judgment. It was 2 scribes allocated. Then I co-wrote a dissenting judgment as well. I then co-wrote 2 other judgments with two other colleagues. So I think in total, if I include the ones that I've co-written as well, it's about 9 judgments.
All right. You've been quite active in the legal bodies even before you became a judge. You were a member of NADEL, the SAULA, the BLA, the usual. And as a judge, you are, I know you for a fact that you are quite active in the South African chapter of the International Association of Women
Yes.
Judges, and that's where you do mentoring and these other good things we should all be doing.
Yes.
All right. And you sit in the council of the University of Limpopo as well, your alma mater.
Yes, that's correct.
Okay, your term runs until 2028.
Yes, that's correct.
And you are involved in the church community as well.
Yes.
I thought you said it as a single parent, you struggle juggling your responsibilities. You seem to be doing quite a lot.
Yeah, it's fortunate that my youngest son decided to go to boarding school, so it gives me a lot of time in my hands.
Okay. How many judgments in all would you say you've written in your judicial life?
It's going to be a little bit of a challenge for me to say, but when
Estimate
I
is fine.
tried to do the exercise to see the ones that I could find on my laptop, because my other laptop got stolen, were about 250.
Any of them reported?
Yes, there are. It's about 10. I'm just talking at the top of my head. There's some
estimates
that
are fine.
appear on my application.
Yes. All right. No, thank you, Judge Masipa. I will hand over to President Mulemela and the other commissioners to put questions to you. President.
Thank you, Chief Justice. Good afternoon, Judge Masipa. Good afternoon.
Afternoon, Judge.
How are you?
I'm well, thanks, and you?
I'm well. Well, you have been interviewed before, right? You have been interviewed for the SCA by the JSC. You have appeared at the JSC.
Yes, I have.
Yes. And subsequent to that interview, you acted again at the SCA. Is that correct?
Yes, I did.
Yes. How did you find the experience?
I think I will say that for me, the atmosphere in the SCA has gotten better and better in time as I go. I'm not saying that there was ever a hostile environment for me. I think it probably came from my side that I was probably finding my feet at a certain point, and it would probably relate to the issues of the 2 initial judgments that I wrote there, and the issues of how I handled them in terms of I think there was a question previously, why did one take 7 months to be handed down and things like that. But where I am now is that I have found ways to deal with issues that would have led to or resulted to something like that.
Sorry, do you have any reserved judgments where you were the scribe at the SCA?
At the SCA?
Yes.
There's a judgment which I'm sure you are aware of that I brought to your attention. It does not appear on my application.
Yes, I am aware about that one. I was referring to a judgment where you were meant to be the scribe.
No, I don't have.
From the outset.
No, I don't have.
Thank you. Thank you, CJ.
Mister?
Thank you very much, CJ. Good afternoon, Judge Masipa.
Afternoon, Minister.
I took interest in your responses to the questionnaire. And I noticed that there's something that you are bringing to the attention of the Commission of the work that you have done. And I'm interested in that. The colloquium you attended this year in Mozambique that talks to the strengthening of judicial responses to terrorism and drug trafficking.
Yes.
Do you mind sharing with us as the Commission your insights in that work and some of the recommendations that you might have made? I took interest in that work.
So the colloquium was held in Mozambique, as you can see. It's a procedural law colloquium which they hold on an annual basis, and they were dealing with issues regarding drug trafficking and human trafficking. I mean, there were speakers from Mexico, from Mozambique, and I was there representing South Africa. There was also somebody from Brazil.
Judge Masipa, sorry to disturb. I'm interested in your paper.
In my paper?
Yes, because it says you presented a paper.
Yes, I did present a paper. So my paper was talking about the problems that we were encountering regarding the issues of the borders between our neighboring countries in respect of the issue, the cross-border, I'm trying to find the word, and on how basically we can work together to assist each other in respect of dealing with issues arising from those things. I spoke about issues regarding, there was a minister from Mozambique who had run away to South Africa, who they tried to extradite and get back to Mozambique, and they had a problem with the extradition process, where we ultimately extradited the minister to the US, and they were showing their displeasure in respect of how we elected to extradite him to the US instead of taking him to them. There was also the issue of the extradition of Shepherd Bushiri that we spoke about. We spoke also about the issues of, it was the issues of finance, how the cartels finance the issue, the trade, basically, the drug traffickers and the human traffickers. And it was mainly indicating the need for the strengthening of the prosecution of our country, working in conjunction with them, together with the policing system, to make sure that those people can be brought to the law.
Maybe just a follow-up. That's why I was saying I'm interested in what you presented. Is it on legal mutual assistance, or is it on the issues that relates to FATF in terms of
Sorry, I missed the first word. I'm sorry.
Oh, okay. Is it my mic not audible? My apologies. I'm saying in your paper, because that's what I was saying, I'm interested in your presentation to the colloquium, because you said you did a presentation. But I'm picking up now, you talking to mutual legal assistance issues. Is it the focus, or was it an analysis of our application of mutual legal assistance tools, or is it the issue of just collaboration in terms of cross-border? And what I wanted to know from your side is what has been your insights? What did you find in terms of what can be strengthened from the judiciary in dealing with such matters? Because it's quite common currently. It's issues that we are grappling with in terms of global, when you look at global issues that we're dealing with around terrorism, around matters that deals, as you say, cross-border. But what has been, I'm not so sure if I'm making sense, what has been your observation? Is it the tools that we use for mutual legal assistance that are not strong, or what was being shared in that regard? Because, as you say, the issues around extradition is within the mutual legal assistance that the Minister of Justice will be responsible for in terms of that work.
It was mainly about the mutual legal assistance, and I actually indicated to them because when I basically prepared to deal with issues of how we deal with extradition processes, and then they dealt with it, I indicated to them as well that it probably would have been best from the way the presentation was that they had somebody else from the prosecution, and I actually recommended, because they said that this was going to be an annual thing, that perhaps next time they need to they insisted that they needed somebody from the judiciary. So I said, you need to invite somebody else from the prosecution who would have a better insight in terms of dealing with issues from that perspective.
Thank you, CJ.
Nasivan?
Thank you, Chief Justice. Judge Masifa, I noticed in your application, you've said you've got 4 reserved judgments. That was a lot of, most of them dated May and one is dated June.
Yes.
Have they been, what's the status of those judgments now?
They were all handed down by the end of August.
Thank you. And you've got 2 part-heard criminal cases. I know that that's largely beyond your control, but what's the position of those?
The second one was finalized shortly after my application was submitted. The first one, a bit of a challenge because as you can see, it's a criminal matter.
Yes.
When the matter was supposed to come back to court for me to finalize it, the accused escaped, and they're still at bay as we speak. One of them I was told so one of them is at bay, one of them I was told was arrested, and I'm told there's an intention to bring an application to separate the trials so I can finalize the matter, since it's coming from 2023, if you can see.
My final question is, what's the average time in which you've taken to hand down your judgments in your division?
In the?
What's the average time you take to hand down your judgments in your division?
I would say 6 months.
Okay, thank you. Thank you, Judge.
Just a reminder, Commissioners, it's 1 question per Commissioner for candidates who previously said there for this same court.
I apologize, I just was on the question of time.
JP Tlaletsi, followed by Professor Marumahai.
Thank you, CJ. Good afternoon, Judge. Just want to give you an opportunity, just an opportunity to comment on the statement made by one of the law bodies, which will be the LSSA. You may have seen that. They say Judge Masipa seems to have a peculiar understanding of what are the judgments that are written by her alone and judgments written by others with which she had concurred. Her difficulty in grasping this distinction raises a matter of concern, as she cannot claim the luxury of any credit as she does for judgments handed down in the name of another judge who is regarded as the author. And for that reason, they say you would need more time to gain confidence of the judges of the SCA to author your own judgments, and as a result, they do not support your
Yes.
your candidature. Will you please just comment on that?
I wasn't too sure if I understood what they meant by that, because, and I asked myself if it was about the fact that on my application I reflected the judgments which I co-wrote with other judges, because those are the only judgments which I have included. I am not laying claim to, for instance, in the time that I've sat in the Supreme Court of Appeals, I've sat in about 49 matters. And I'm not laying claim to all the 49 matters where I concurred or dissented in. I brought to your attention matters which I have written judgments on, and matters which I have co-written judgments on. And as I explained earlier on, some of those that I have co-written were from the beginning allocated to 2 scribes. So I'm not too sure. I did not really understand what they meant, whether they were suggesting that the fact that I've concurred in judgments, then it means that I'm laying a claim to that. Because if I was doing that, then I'd probably be sitting here and saying, I've written maybe 350 judgments because I have sat in a lot of judgments, appeal judgments in the full court or the full bench, and I'm not laying claim to any one of them where I have not participated in writing.
Thank you, C.
Professor?
Thank you, CJ. Good afternoon, Judge. Yeah. I have been doing some research in the processes of the Superior Court in South Africa.
Sorry, I've missed your first.
I was saying that I've been doing some research on the processes of Superior Courts in South Africa, particularly the Supreme Court of Appeal and the Constitutional Court.
Yeah.
I'm not sure if you are aware of this, or it's something that generally the judges of the court are. When there is an order refusing leave to appeal in that court,
yeah,
and that order is handed down by 2 judges today,
yes,
you find that that order is not given to the parties today. It is given to the parties a week or 2 later. And when one looks at the prospects or the opportunities for the parties to take the matter forward, there are timelines that the parties must comply with. I'm not sure, are you aware of this? Is it a challenge, or am I just raising something that is non-existent?
I'm not aware of that in the Supreme Court of Appeals. I do not want to lie. But I am aware, for instance, in our courts that you would make an order today, and then the matter the files will be handed over to the typist, and it'll take approximately 7 days before the order goes out, which becomes a problem. But obviously, with urgent matters, there's directions where parties must come with the orders to make sure that their orders go out timelessly. But I agree with you that it may create a problem. The only issue that, the only question that I ask myself is, what does the stamp say on well, no. I was actually thinking, what does the stamp say on the order that goes out? Because I'm wondering if they will not say the date that we receive the order is stamped is the date when the order is said to have come to our attention, and then we can act on that.
Yes, the further challenge is the issue of coordination and costs. But anyway, let me leave it there. Thank you very much, CJ.
Commissioner Baloyi, Commissioner Steinberg, Commissioner Pillay.
Good afternoon, Judge Masipa.
Afternoon, Commissioner.
Yes, you've included in your list of judgments the matter of
Freedom and the Law versus the Judicial Service Commission, and this is the matter that related to a decision of the JSC regarding Judge Justice Mutata then. You remember the matter?
Yes, I do.
Yes. Now you wrote with Judge Muchumi.
Yes.
And it indicates the judgment, your judgment, the co-written judgment is a dissenting judgment. And my question is nearly but not quite along the vein that the judge president raised with you about how you identify judgments. I mean, on my reading of your judgment, the only difference with the main judgment or with the majority judgment that I seem to note, unless I read it wrong, is in the order of remittal and how wide it is. Your order is a narrower order; it directs certain specific things to be done. And the majority judgment says it must be the matter must be remitted to be dealt with under Section 24 of the JSC Act. Now, in the body of the judgment, in fact, until I get to the order, it's not clear to me what dissension there is, because you seem to agree with the majority judgment, and you also add your own reasoning, but not disagreeing with anything, at least so far as I've understood and read that judgment. And then it seems out of nowhere, you then come with an order, a different order, and it's not explained, it's not reasoned, it's not justified. Now, this, your judgment, has been mentioned by the law bodies as an indication of independence, your independent thinking. And I'm not sure that that is apparent from your judgment. Can you perhaps just explain the thinking, firstly, why the order, a different order from the majority, but also why you've considered it to be a dissenting judgment? Thank you.
I have not read it recently, but as far as I remember, the issue that we were dissenting about was in respect of the interpretation of that's, I think, Section 20, bracket 1. In our view, the clause required that the Judicial Services Commission considers the recommendations, the decision of the tribunal. And we were of the view that the Commission had not considered that decision. And I thought it came out clear on the judgment, but as I say, I have not read it. That they had not considered that decision, and that is why we then decided that it needed to come back. And also, there was also an issue of the fact that there was a new committee. I think there was, in addition to the fact that there was a new committee, there was some indication that during the supposed to be consideration of that decision by the tribunal, there were some disturbances that happened, and we were not satisfied that it was given proper attention and therefore properly considered, and hence we said that it needed to come back to be properly considered by the Judicial Services Commission.
Ms. Steinberg? Good afternoon, Judge Masipa.
Afternoon, Commissioner.
One of the law bodies highlighted your judgment in the Body Corporate of Marine Sands case, which the SCA set aside. And my question is based on that judgment. If it if a judge considers a legislative provision to be unfair to one of the parties, what are his or her degrees of freedom in dealing with that unfairness?
Is it generally, or is it in respect of that particular judgment?
It's a general question based on what the SCA had said in that judgment.
I'm quiet because I'm thinking, I don't think that it goes as far as going to one having to consider the provision of Section 172 of the Constitution. I think that's taking it a little bit far. So I think I would have to consider the facts of a case at that point.
What the court said is that once the meaning of a statutory provision is clear and unambiguous, it is the function of the court to give effect thereto. It's not for a court to substitute what it regards as reasonable, sensible, or businesslike.
I'm sorry, I'm really struggling to hear you.
Sorry about that. We're having a bit of difficulty with the acoustics, Judge Masipa. The court said once the meaning of a statutory provision is clear and unambiguous, it is the function of a court to give effect thereto. It is not for a court to substitute what it regards as reasonable, sensible, businesslike, or fair for the words actually used, as this would cross the divide between interpretation and legislation.
Yes, that's correct.
And that was the critique of your judgment,
my judgment,
the basis on which it was set aside.
Yes.
It's actually a separation of powers issue.
Yes,
Right.
true, that's correct.
Thank you.
Commissioner Pillay. Thank you, Chief Justice. Good afternoon, Judge Masipa.
Afternoon, Commissioner.
I just wanted to ask you about your Lowe versus Patel judgment, where you were described Lowe versus Patel.
Yes.
One of the issues you dealt with in that judgment was how a court should deal with conflicting expert evidence.
Yes.
And there's a line in your judgment where you say it is improper to prefer one expert view over the other. But what you don't do is then tell a court how it should resolve a conflict in the opinion between two experts.
I'm quiet because I'm remembering that I think there's a judgment that actually deals with that says that it is for the court to arrive at its own conclusion after considering those conflicting expert reports. I do not recall the judgment. And I don't remember. I would have thought that I dealt with that in the judgment, but I don't remember.
Yeah. So what you don't deal with, I mean, you cover the case law on how to deal with expert evidence generally, and then you get to the real nub of that issue, which is if you have two conflicting views, how you resolve that conflict. And unfortunately, you say you should not. It's improper to prefer one over the other. But then you don't go one step further and say, well, this is how you should properly resolve a conflict between two experts. And it is a fraught subject. It's not something that's easily dealt with.
So I missed the last question?
No, I'm saying it is a fraught point. It's difficult to resolve if the court is not the expert and it's got two expert opinions before it and they are conflicting as they usually are. How then does the court resolve that conflict?
I'm going to go back to the answer that I gave you because I am sure there's a judgment that says it is ultimately the court that determines what is sufficient evidence before it, and not for the experts to decide on that issue.
Thank you, Judge. Thank you, Chief Justice.
Yes, thank you, Chief Justice. Judge Masipa, I just want to get a sense of, I've been looking at your record at the SCA, and I found that there were 10 judgments. One, you dissented, you wrote that by yourself. 3, I think, were majority, even if there was a dissent like the low judgment. I think Judge Basson dissented.
Yeah.
And then there were 6 others where you co-wrote, and out of that 6, 2, you say that from the onset, the presiding judge allocated 2 scribes. And then 4 others, which were also co-written, but presumably in relation to that 4, you were the allocated judge. Is that correct?
I was there?
You were the allocated judge, the scribe.
No, because you're counting, for instance, the freedom under law versus the Judicial Services Commission matter, where I co-wrote the dissenting judgment. I was not allocated to write the dissenting judgment. It's something that obviously just came. So out of, well, when I mentioned 2 matters which were allocated for me to co-write, and I mentioned 2 other matters where I was the allocated judge. The first matter is...
Sorry, there were 6 that are co-written.
Is it 6?
Yes, 6. It's RAF versus Mabunda.
Yes.
Snowy Owl Properties versus Silia.
Sorry, I missed the second one?
Snowy Owl Properties, Owl Properties versus Silia.
Yes, I know that. Okay.
Discovery Inshore versus Masindi. MEC for Roads and Transport versus Bovicon.
Yes.
Freedom Under Law versus JSC, and Spa Group versus 12 Gods Supermarket. So that's 6.
So the Snowy Owl is the one that I think when I mentioned and I said 9 matters, I had not counted. I co-wrote a consensus judgment with Judge Hughes. We were also not allocated to write that. So it's actually only 2 judgments that I was allocated to write, which were co-written, which is the RAF matter and the SPA matter.
Yes. Now that's my point really was to ask, when I look at the record, out of the 10, only 3 where you wrote for the majority alone, 1 you wrote a dissent alone, and then 6, which is the majority, are co-written. Just want to understand, why is it so that the majority of the judgments in the SCA where you were involved were co-written?
Well, as I indicated, the first 2 were allocated like that from the beginning. So you're counting them as part of the 6. Then the other 2 were dissenting judgments that we agreed to dissent with. I was not allocated to co-write. So as I already indicated, it's only 2 judgments out of the 10 where I was allocated as a scribe that were co-written.
And how did that come about?
In respect of the first matter, the RAF matter, I wrote the judgment and I circulated it within term. The judge that co-wrote the judgment with me went through it and made some comments. His comments were, you wrote an extensive judgment. It's quite detailed. I would exclude, for instance, one of the issues that were being dealt with in that matter was mootness. I dealt extensively with the issue of mootness, and he said, because you're granting, you're allowing the matter to proceed, it is not necessary for you to deal extensively with this issue of mootness.
Sorry, Judge, I really don't want to get into the weeds of it. I think it's really the principle. You've been asked to write a judgment. It ends up with two names.
Yeah.
I just want to understand why it's not coming under your name.
Because of the contribution that the other judge made in the matter, he indicated that he was of the view that his name needed to be included there, and I accepted that. He did make extensive contribution, and it was only fair that his name be included. In respect of the second matter, something similar, although I would not attribute it to that, but it's something similar. I believe that I did quite a lot of work in that matter, and but a senior judge said to me, I did some work and my name should be included, and I obliged.
Okay, so in relation to those cases, your belief is that they should not have been included, or you accept that they were correctly included, the other judges who wanted their names reflected?
So under?
I'm saying the other judges who wanted their names reflected in the judgment. Are you saying that in your assessment of their contribution, they should not have been included as co-writers? You should have been the only one credited with writing the judgment?
In one of them, yes.
Thank you, Sir.
Any further questions, colleagues? No. Thank you very much for making yourself available for this interview, Judge Masipa. Unless you have anything to say to us, you are free to go. Thank you.
Thank you, Chief Justice, and thank you to everyone.
from the University of Zululand,
Yes.
or what we called Ongoye back in its day,
Yes, yeah.
which you obtained in 1988. But you had been a nurse before you veered into the legal field. Was that fresh from high school?
It was fresh from the next day after matric, CJ.
How did you find that experience?
Very intimidating. I was very young then, about 19 years old, and having to deal with blood and everything. It wasn't an easy experience for me.
Can you imagine? But experiences like that build character.
Yeah, I agree.
So you left Ernest Oppenheimer Hospital and worked for a brief spell at a construction company, LTA. Does that company still exist?
I
used to
don't
be
think
big
so.
in its day.
I don't think so. I haven't seen it in a while.
Yeah.
CJ.
And then you did your articles. No, you worked as a clerk and then did articles. So at which stage did you do your... I'm trying to synchronize this CV. You left LTA construction to pursue your studies, your legal studies.
To finalize the degree.
Or you had already started it?
No, yeah, I had already started it.
Okay.
In fact, I broke at the third year, did not have money to complete the fourth year.
But then you somehow made a plan. So between 1990 and 2005, you were an attorney.
I was.
And you joined the Department of Justice as a magistrate, where you remained for 10 years.
I did, CJ.
In the district court.
In the district court.
Then for a brief spell, you acted as a regional court magistrate.
I did, CJ.
All right. And started acting as a judge.
I did.
Was that in the Bloemfontein High Court?
Bloemfontein High Court, CJ.
All right. So you acted until 2018. You had long spells between 2016 and April 2018 until your permanent appointment in July 2018.
True, CJ.
All right. And since your permanent appointment, you've built your way up to earning an invitation to the Supreme Court of Appeal.
True, CJ.
I'm counting you've acted for 3 terms?
For 3 terms, CJ.
The last one ending in May 2025.
True.
Did you get an opportunity to write judgments in the SCA?
I did.
How many?
I wrote 5.
In 3 terms, that's quite an output. How did you find judgment writing in that court?
I think it was a bit different, but not necessarily that different. But the mere fact that one worked in teams, your judgments became better. And, discussions, feedbacks from colleagues, and in my view, it was good.
I get the impression that you didn't struggle.
No, I did not.
Okay. And you would have written judgments in the High Court as well?
I did.
Any reported?
At the SCA, I had 3 which were reported, and I also have some which I've listed in my CV in the High Court.
Right. I'm just looking. Okay, you listed reserve judgments, but only 3 actually. would be concerning. Have you delivered any of these judgments?
All of them have been
to date?
delivered.
All of them?
All of them have
All
been
right.
delivered.
So your bill is clean. All right. And you are in good health.
Pardon?
You are in good health.
I am.
I'm looking at your answer in that portion of your questionnaire. Okay, I will give President Mulemela and the rest of the commissioners an opportunity to put questions to you, if they have any.
Thank you, CJ.
Good afternoon, Judge Muditsani.
Good afternoon.
How are you?
I'm okay, President. Just anxious, but I'm okay.
Yes. You and I have known each other for a very long time. We were contemporaries in practice.
True.
And when you were appointed at the High Court, I was the judge president in that court.
Indeed so, President.
Yes. So my question, the CJ has covered a lot of ground. I think what I want to ask you at this stage is how you found the transition from being a judge of the High Court to being a justice of the Supreme Court.
It was good, President. It was a good experience. And I must say, I really enjoyed it.
And how would you describe the environment at the SCA? You liked it?
For me, it was collegial. It was easy to knock on any colleague's door and bounce up anything. I mean, after the hearings, if there was anything that I wanted to bounce with any of the colleagues, even if in a matter that I was not a scribe, I would always find it easy to interact with the colleagues.
Yes. What was your average turnaround time in terms of circulating your judgments to your colleagues?
Almost 2 months.
2 months.
2 months to 3 months.
Thank you, Judge Mudisa. Thank you, CJ.
Thank you.
Thank you, President. Minister.
Thank you very much, CJ. Good afternoon, Judge Muditswane.
Good afternoon, Commissioner.
How are you?
I'm okay.
I'm okay. Looking at your work, you were magistrate before you ascended to the High Court. And in this capacity, you've dealt with quite a number of issues at magistracy level, including peer training of other colleagues. Magistracy, from where we're sitting, does play a critical role in terms of access to justice, especially for the vulnerable communities. But what we get often, as you would have been, I don't take that you've been away from that long, looking at when you left from being a magistrate. The colleagues do have a view that, or believe that they play a critical role for access to justice in our communities because they are closer. However, they do raise the issue that there isn't necessary support or sufficient support that is provided to them. Are you able to share with us the insights, the recommendations that would help us to improve that area of work from your experience and what you have found over time, the differences maybe between what you did as a magistrate and now as a judge? Thank you.
Thank you, Commissioner. Most important aspect of the magistracy is that you deal with ordinary people in their ordinary type of life. And then you find that a lot of cases which one encounters in the magistrate court are not matters which generally find their way in the High Court. A simple example would be one would have a lot of cases where you are in a small area dealing with your ESTA cases, your children's court matters, your GBV cases where the Domestic Violence Act is involved. And you'd always find that, especially like myself, I was a magistrate in a small town, Edinburgh, and you are just alone there. And it's up to you to interact with the other colleagues in order to dispense justice. And in my view, it is true that magistrates feel that there's not much support. But with time, I've realized that SAJ has been making inroads and allowing, people to be empowered in the form of training. So even irrespective of whether one is in a small town, there is always the opportunity to learn. It only depends on an individual. It only depends on an individual if the individual wants to empower himself or herself. So I believe there is some form of support, although one cannot really say it is enough. I mean, training can never be enough, in my view.
Thank you. Thank you.
Thank you very much, CJ. Good afternoon.
Good afternoon, Commissioner.
I have one question for you. Usually, when somebody applies for leave to appeal to the Supreme Court of Appeal, not usually, but at times, the two judges that hear or that decide on that leave to appeal, they may decide that there is merit on the application, but the issues do not merit being heard by the Supreme Court of Appeal. And then they will take the matter and decide that it should be heard rather by the full court of the High Court. There are two schools of thought in as far as furnishing security of cost is concerned. On the one hand, there is a view that in terms of Rule 49, sub-Rule 13 of the Uniform Rules of Court, the applicant ought to furnish security for costs. Another view is that the Rule 9 of the Supreme Court of Appeal rules does not make provision for the applicant to furnish those costs. I'm not really sure if you have encountered such an application before. My question to you is, what is the correct legal position in as far as furnishing security of costs is concerned, where leave to appeal has been granted by the Supreme Court of Appeal to the full court of the High Court?
May I start it this way, Commissioner? In the magistrate court, the issue of security is peremptory when one has to appeal. I have not encountered the situation that you raise in the appeal court, in the Supreme Court of Appeal, where security would be an issue. And my view is, even in the magistrate court, I honestly do not think it's a good thing that litigants must be asked to furnish security when they want to appeal. And my view, consequently, is that it shouldn't happen.
So sorry, Judge. Look, I understand that, but the thing is, there is a rule in the Uniform Rules of Court that makes provision for it, unless somebody has been excused by the court. But that ruling is, as far as I understand it, in relation to a single judge who has actually granted leave to appeal. But what I'm talking about now is the single judge refused leave to appeal, and then the person who lost petitions the Supreme Court of Appeal, and then the Supreme Court of Appeal grants leave to appeal, but only to the full court. So what I'm asking you in relation to the rules that I've put to you, Rule 9 of the Supreme Court of Appeal, and
there's no provision for that. I mean, there's no. My view is that there's no provision. Once the matter comes from the Supreme Court of Appeal and sent back to the full court, one cannot insist on.
Oh, I understand.
That's my view.
Okay, no, thank you very much, Judge. Thank you, CJ.
Commissioner Stelzberg. I missed them. All right, Commissioner Mwimang, followed by Commissioner Hassan.
Thank you, CJ. Good afternoon, Judge Muditswani.
Good afternoon, Commissioner.
Thank you. Just one from my side. I'm more interested in the role of the Supreme Court of Appeal on promoting constitutionalism. Does it have any role to play in promoting transformative justice?
It does, Commissioner. It does. The question of constitutionalism is not confined to the Constitutional Court. The Supreme Court of Appeal also has a role to play, and in my view, it does have.
Thank you, Judge. Thank you, CJ.
Thank you very much, Chief Justice. I have a question related to the S versus BAM case, in which, in paragraph 17 of the judgment, you wrote, rape in any form is a heinous crime that violates the dignity, privacy, and bodily integrity of the victim, and that sentencing must also affirm the victim's dignity. And so the question is, from your experience hearing GBV appeals, how should appellate courts evolve their approach so that dignity and due process walk along together, especially around credibility assessments and trauma-informed reasoning?
Can I have the question again, especially in light of where you referred to credibility?
So I wanted to understand, from your experience hearing a number of different GBV cases, how do you think, for example, the SCA could evolve the approach so that dignity and due process walk along together, but particularly when it comes to credibility assessments of victims, and often what happens is that trauma-informed reasoning?
Thank you, Commissioner. Questions of rape and GBV have to be dealt with sensitively. And my view is that when one deals with that, the SCA, although they are not a court of first instance and not having the opportunity of looking at the testimony or the complainant, can also from the record look at how issues of credibility should be dealt with. And in that way, my view is that the courts, not only the Supreme Court of Appeal, must be sensitive to gender-based matters, including rape. Even the complainants, when they testify, one must look at, be sensitive that we should avoid having secondary trauma when matters are done. I mean, one cannot really foul the complainants in rape cases where they are unable to articulate their cases. At times, they are still scared. At times, others believe, even if you say to them, you can do this matter in camera, they still insist to do it in an open court. And once they testify, courts should be sensitive to it, and the record should reflect that, so that the SCA must be able to deal with it and provide guidance.
If I could just expand on that, CJ, given our femicide crisis in the country, and of course GBV, and you mentioned it a little bit, but I want you to unpack on some of the practical steps. You're interviewing to be a judge of the SCA, and so what practical steps do you think could be taken to guide lower courts towards that kind of consistency? You mentioned it, but also the empathy in how we adjudicate these cases.
My view is when one deals with such cases, one should understand the scourge of gender-based violence, the scourge of rape. And one must come with an approach which should be sensitive to the plight of women and vulnerable children. One should also look at ways of not expecting of the complainants in trials of this nature to justify their conduct.
Okay, I was sort of hoping to hear some practical steps, because I agree, and I think there's some agreement in principle about the sensitivity of it, but do you have any thoughts on the practical steps?
I cannot think of any at this stage.
Thank you.
The candidate has given his answer, Commissioner Hassan. You take it or leave it. Commissioner Steinberg.
Good afternoon, Judge. I'm over here.
Good afternoon.
Do you have your application in front of you?
I have.
Would you turn to page 14 of your application?
40.
14.
I have it.
So that's Annexure PEM 2.
I have it, Commissioner.
So that annexure answers the question in the questionnaire to list no more than 10 judgments and to tell the court why you, to tell the commission why you consider them to be significant. I have two questions.
Thank you.
The one is, in quite a few of them, there are ... So in number 1, the final sentence says the legal conclusions for the purposes of the Prescription Act should be ... to non-legal practitioners. And the next one, SV Balm, the case of speeding, the case dealt with failure of the court to satisfy ... during questioning. Same in number 6. And I'm wondering what to make of that.
I must apologize. I must have skipped this one because it was typed. I thought I checked it. Usually the person who typed for me, if she does not see, she would write that ... And I must apologize. It must have been a mishap on my side, oversight on my side.
My second question is, you haven't answered the question as to why they're significant. To me, possibly except for the first one, which is a SCA judgment, they look like very ordinary cases that deal with speeding, wrongful termination of a tender, an interdict, etc., etc. Could you elaborate on why you consider these judgments significant?
When one comes to the question of speeding, I believe in the Free State there was at one stage a unit of speed, and the lower courts were inundated with a lot of cases which for people who have been arrested and charged for exceeding the speed limits. Every now and then, such cases people would be convicted, and most of them they would then go to the High Court as automatic reviews in terms of Section 302. And then I then realized that it was necessary that one should give guidance to the lower courts on how speeding cases should be dealt with. This one of the speed was, in my view, important in that respect.
And in any of the others?
The one of Malala.
Sorry, which one?
Number 5. It was about the disciplinary procedures which were followed in order to charge Mr. Malala. Then Mr. Malala wanted to bring an interdict so that he could not be charged, and said that an interdict was in fact the disciplinary proceedings which were to be instituted had to be done in terms of a certain regime, and he wanted the regime to be followed, and it was important in that respect.
But why is that significant in any way?
I cannot take it any further.
I must just express some disquiet about the fact that you hadn't read this through before you submitted it, and it doesn't answer the question. It's an important criteria for us to look at, as to whether a High Court judge has written significant judges in order to justify his or her elevation. Thank you.
Thank you.
Can I make a follow-up, Chief Justice?
Yes.
Thank you. I think the problem, Judge, is not only about the way in which you've completed your application. It also seems to filter through to your judgments. Let me give you 2 examples which have been highlighted for us by the General Counsel of the Bar. The first one is a case of Mafube Business Forum versus the Premier of the Free State, recently decided on the 25th of March 2025. You remember the judgment?
I do, Commissioner.
The full bench found that you failed to consider the declaratory and mandatory orders and limited yourself only to the contempt issue. And that was a material misdirection on your part. Then there is another case called Municipal Workers Retirement Fund versus Kopanong Local Municipality and another. That was delivered on the 19th of September 2019, which also seems to have been a full bench appeal, where they said that you granted an order which had not been sought even by the municipality itself. And then there is, in that same judgment, you mischaracterized the submissions that were made by the advocates. I think Mr. Berger had appeared in front of you. That's what they say at paragraph 7.2.3. So the problem is not only what Commissioner Steinberg is putting, that you were careless in the completion of your form to this body, but it seems you are also careless in the manner in which you record the facts and decide the cases. Do you have any response?
When the first case of Mafube, it was a contempt of court. True, the applicants were saying they were also seeking a structural interdict. When dealing with the facts of the case, I could not find any mala fides on the part of the municipality. As a result, that's where I ended, because I said that element was lacking. The municipality had done everything that they could in order to stop the sewage, and they had also solicited the help of the national government, and COCTA had also given them an amount of 5 million in order to work on the question of spillage. And as a result, they could indicate that they had nothing. I mean, there was a Section 139 intervention in place, and still there was a problem. And with hindsight, maybe I agree that I should have gone further, but the thinking at the Marafide.
No, I think the problem is that what the GCB is saying is that a party comes to court to ask for 3 distinct orders. One is contempt of a previous order. Second is a declaratory order that the community's rights under Section 24 have been breached by the conduct of the municipality. The third is a supervisory order dictating the conduct of the municipality in the future. What you do, you decide the first issue, you leave out the second and the third issue. They are complaining about that carelessness.
With hindsight, I should have done better, I agree, Commissioner.
Thank you, Sir.
Commissioner Mange?
I'm covered by the questions by Commissioner Ngubedwe. Thank you very much, CJ.
All right. We have finished with you, Judge Motiswane. Thank you very much for making yourself available for this position. Wishing you all the best. You are excused.
Thank you, CJ. Thank you, Commissioners.
They have any sympathy.
No.
You grilled people sitting there
my
for 3
fear.
years.
Thank you.
Okay. Sky.
That is correct, Chief Justice.
And then did certificates in shipping
Yes.
and in project management.
That's correct, yes.
Now, in respect of the shipping one, you did not end there. You had a stint in New York in a shipping law firm. What was that about?
Yes. Well, first of all, Chief Justice, one of the reasons I went to KZN is because I did my pupillage there, and one of our lecturers, Mr. Advocate Maniwick, SC, was one of the specialists in shipping law. So he was always drumming it into our heads that one of us must actually do it. So I took interest in it, and I joined the Maritime Law Association, and it was through that, then there was invitation for people to apply to be trained in New York at the law firm Holland and Knight, which does that training on a yearly basis. They take away foreign students. And I went there as a trainee, and that was in August of 2004, and returned in January of 2005.
So you were there for 6 months,
yes, but the training is quite intense, because if there has been a collision at sea, then they do in America what is called depositions. So they receive all the evidence immediately after the collision, and that's a formal process. It's like a court sitting, but it's headed by a senior partner, and the law firm where I was attached to is one of the leading law firms in maritime. And I was trained under Mr. Rambush, who had appointed certain Mr. Hooper, who was voted that very year one of the leading maritime specialists in New York. So then also at the same time attended Fordham University. The law firm organized that I attend that university on a weekly basis, lectures on a weekly basis. And we were lectured by one Professor Sweeney, and anyone who is in the maritime business knows a lot about him. He used to practice within our shores here. He would fly from New York to come and do cases here. So I got the benefit of being lectured by him in maritime law. And I went to state district courts with the partners of the law firm. And I prepared opinions whenever there was a maritime issue. They would invite one to prepare opinions for them. And they had a series which was called Rules of the Road. That series dealt largely with maritime matters. And I was asked that year, because I was there, to update that series. And I had the pleasure of being told the following year, after I had left, that my ideas on the series had been accepted at the seminar that they had held after I left. That benefit of having been exposed to that led to me being able to work and be a junior to now retired Judge Wallis, Justice Wallis, and he led me in several maritime matters. And then thereafter, I got the support. There were people like Tato Tsaute, who were employed by the Port of Durban at the time, and they were legal advisors there, who were just giving me work in that field. So that's how I got a lot of training, and I then imparted the skill to some of the juniors as well. And I'm happy to announce maybe that 2 of those juniors have now they've got master's degree in maritime law. Yes.
That's quite an achievement. Yes. So you ended up being an expert in shipping law yourself.
In a way, yes.
Yeah. I remember the excitement in the Eastern Cape Division of the High Court at the prospect of having you appointed to that court with your expertise, which is rare, especially in black law practitioners.
Yes.
Are there who else?
There's very few, but in Durban, the class is quite huge in Durban. But I think the challenge is whether they want to come into practice or they get employed by the ports authorities and the maritime authorities, because there's various bodies within the maritime industry that employs them. So you don't get to really see a lot of them within the court setting.
Yeah,
Yes.
pity. All right. So to go back to your judicial career, which was preceded by a few things you did before you became an advocate.
Yes.
You started working for the Sky government.
Yes, as a prosecutor, immediately when I qualified after my BUris degree, I was employed to prosecute as a district prosecutor in the old Sky.
Yeah.
Yes, and
For 2 years. No, actually longer. You were a public prosecutor for 2 years, then you
yes,
went
and
up
then
the
I
ranks
left
as
to
a-
do my LLB
Yeah.
again, and then I went back again to being a state advocate.
Yes.
In the Sky. Yes,
and that was another 3 years in that department.
that's correct. Yes.
All right. And you list having held the position of senior legal administrative officer.
Yes.
What
was
did you do there?
This was during the transition stage from the homelands to this new government. And at the time, they were setting up different offices, and I was invited to apply for that position because they needed someone who had the knowledge of the law in the area. I don't know what else they considered, but I was asked and I applied for that position. And I was attached to the office of the Director General, Mr. Tozamile Bota at the time. And it was when, in fact, they didn't even know what to call my title. I think I became the first senior legal admin officer. They didn't know what title to give to a person holding that position because they had state law advisors. So I was not a state law advisor. But then they created, I think Mr. Zem Titus came up with that title.
One of the best state law advisors.
Yes.
Black state law advisors this country has seen.
Yes.
All right, then you went to do your pupillage at the Durban Bar.
That is correct, yes.
And practice there.
Yes. After pupillage, I came back to the Eastern Cape. I practiced in Bisho for about 5 years.
Yes, you did.
Yes. Then in 2002, then I relocated then to Durban. Yes.
And you practiced there, took silk in 2011.
Yes.
And then did a few other things while you were practicing, including
Yes.
working for the State Capture Commission. How long were you with that commission? 3 years?
The state capture.
Yeah.
The state, yes, for 2 years, Chief Justice, because although I left at the time COVID set in, I actually finished with the commission at the end of that year because there were still some reports to submit. Yes.
And then some people persuaded you to make yourself available for the bench.
Yes.
And thankfully you agreed.
Yes, I did. Thank you.
All right. You've acted at the SCA already?
I have, yes.
When?
Yes. I started in December last year until June of this year, and I am acting currently.
Until when?
Until end of November.
All right.
Yes.
And that reserve judgment you listed in your...
That was delivered
a while back.
Yes, on the 15th of July. Yes.
Okay. You've been involved in a lot of things. You have been involved with our legal bodies, the BLA, AFT, SAULA, GCB, and you've held senior positions in their executive committees and chaired others, and so on.
Yes.
And the LPC, and now you are a member of the South African chapter of
yes
the Women.
That is correct. Yes.
Which is all a woman judge can be, really.
Yes.
With all the restrictions. All right. What else am I leaving out? Your CV is long. No. I'll stop there and leave it to the other commissioners to tease out what you have to offer to this position. Thank you. Thank you, Chief Justice. President Muleme.
Thank you, CJ. Good afternoon, Justice.
Good afternoon, President.
How are you?
Good afternoon. Thank you.
Okay. How did you find the transition from being a permanent judge of the Eastern Cape Division to being a justice of the Supreme Court of Appeal?
I found it quite enriching and enlightening. I think the beauty about acting at the SCA is the ability to get all the researchers that assist with the work that you're doing. That's a plus, because in the high courts there aren't too many researchers, and even if we are too many for them to actually focus on something. And secondly, the support that you're getting from the judges when you go and you seek support, and I got that a lot. And the environment, and also the type of the work that you come across. I mean, with those petitions, you move from civil work to crime and to, I mean, everything is just there. In a week's time, you would have covered a range of legal matters. I found the environment quite conducive, and also enabling one to be able to produce good work because of the support and the manner in which the court, because it's an old machine, it runs like an old machine, and you know that this is what you've been given, this is what you need to do. I enjoyed that a lot. Yes.
Yes. Would you say that you have been exposed to a wide spectrum of legal work at the SCA?
I have from tax law, from my judgments, they are on insolvency law, tax law, on contempt of court, on criminal law, those that I have written or co-scribed, and also the petitions themselves, they really do, because you have to discuss that petition with a senior judge. That too, it also enriches your knowledge in all spheres within the legal profession. Yes.
Yes, and if my memory serves me well, you have been a panel member in some of complex appeals where the record of appeal was actually voluminous.
Yes.
Including the one that you will be participating in.
Yes.
In November.
Yes, that is correct. Yes.
Did you find that it was easy to deal with such complex matters?
I found it quite easy because I've practiced a lot in that court. As an advocate, senior counsel, in fact, I've appeared more at the SCA than I've appeared at the Constitutional Court. So you always just know that because there's different ways, you know that you will not be getting heads of argument that are 100 pages, things like those. So you always know how the system works from having practiced there as a practitioner, and also having read a lot of documentation as well as a practitioner. You always develop a particular system of how you read. And once you've managed that system and you read, then it becomes easier to look at what the issues are. Then by the time the matter gets heard, you have an idea exactly of what the case is all about, and you can't therefore be found to be wanting when questions have to be put to the practitioners.
Yes, thank you very much. In fact, your response accords with the reviews that have been given about you by, in fact, all the law bodies that responded. So
thank you.
It accords with that. Thank you. Thank you, Judge Norman. Thank you, CJ.
Thank you, President. Thank you.
Minister?
Thank you very much, CJ. Good afternoon, Judge Norman.
Good afternoon, Minister.
How are you?
I'm very well, thank you, Minister. How are you?
I'm okay.
Yes.
I got interested and I listened as CJ was going through with you the issues, the work that you're doing in the maritime. Okay. I think it's quite exciting.
Yes.
And quite rare to find. And what intrigued as I was looking at this and listening to you, because one of the issues that has been raised by Asia African Legal Consultative Organization has been that both in terms of developing countries, we do not have quite sufficient growth or even have not done much in understanding the law of the sea and supporting the work that needs to be done there. But also we are found wanting in terms of development of rules, laws and policies just that regulates that. That's why I got excited when I saw your work, because it's something that I started working on maybe earlier on this year, just to look at what we can. So what do you think we should be able to do to pay attention to this area? And I noted that you're saying in Devon we've got quite few, but they do not come into the legal space. Are you maybe able to share what constrains them from coming? Is it pay? It's whether the areas offer more? Because if you do in terms of the work, either you as an advocate given that work, because it's companies, they normally tend to pay much better compared to other cases. But what do you think it's the issue, and what is it that we need? I'm looking at what is it that we need to do to unlock this area of work for more potential of the country to be able to be competitive, as we know that this is a growing trade area beyond just having approvals of your cargo ship and offshore drilling. Thanks.
Thank you. Thank you, Minister. Well, first of all, I think the country does have an interest because it's a trade issue. So it means it affects everyone. I remember in 2004, there was a conference in Vienna where COXA, which is the Carrier of Goods by Sea Act, was going to be amended. And the US, because it preferred certain trade relations and was key, and it was running with that workshop, and South Africa was not represented. And I wrote to the Minister of Transport when I was in the US, and I said, I've just been roped in to assist the US in improving its trade relations with South Africa and the amendments that are being sought, but South Africa is not represented. And I got a response almost immediately, and I was happy to be told by the partner that attended the conference that South Africa was indeed represented. Coming back to what can be done, it's a very big industry. That transport industry, the marine, the fishing, all of that is a very huge industry. And government can do so by simply making sure that from the universities, those students that have an interest in maritime get the kind of exposure, even if it's going to create. I remember Portnet in Durban, they were funding students to study maritime law. Not only that, but they were giving lectures and seminars so that students can actually get the practical feel of what happens within that world. But also within the practice as practitioners, it becomes very difficult to simply swim in as a junior. You've got to have a leader that's going to introduce you to it, because it can be quite complex and it needs somebody who really is going to be able to lead that path. But also and you find that it's only a few places that have it within government. You'll have it in Durban where you've got the ports, then it's easier to have it. So I think it's a question of really creating some seminars and inviting students to come so that they can decide where they want to go. And if the state has got a few that the state can look at and say, we want you to represent us, then the state could do so. I remember Professor Hay, who is also a lead in maritime, used to complain that government was not doing much to really attract the skill within itself, because you need to have, in fact, he was even suggesting that a maritime lawyer must actually head a particular division that has got, that deals with maritime matters. So I guess it's a question of really marketing it within government so that people know that there is this, and also making sure that because you get involved in that litigation, you use them, those that have been trained as well. Yes, thank you.
Thank you.
Thank you, CJ. Good afternoon, Judge.
Good afternoon, Judge President.
Yes, I'm limited to one question.
Yes.
So I'll try and contextualize it. under the judgments that we have listed as having been reported, we've
Yes.
got one in which we have dissenting judgment by Kun J.A. with Unterhalter J.A. concurring. And the third one is the state versus Tabete.
Yes.
And we note that it's co-written with Skippers J.A.
Yes.
Are you free to share the circumstances in which there had to be a co-scribe or you had to co-scribe with someone? Was it capacity issues or was it something juicy on a point of law or what?
I do not know. I think the president allocated it to us, but I think the volume in that matter was huge. And the legal questions that were involved, I think there were about 13 legal questions that had to be decided in that matter. And because I had also, well, we worked together as a team. It was not a question of anyone. We were working even on Saturdays. It was like, in fact, it reminded me as if we were back in practice, because we would be at chambers until late in the evening, just debating the issues. And then once you get to your place, he gets to his place, he phones, he says, Tandy, I think we got it wrong there. I think let's just debate it again. So it was such a pleasure to work with a senior judge on a matter such as that one, because it involved a lot of questions of the law, which are quite intricate, which most times people just overlook it. For instance, a person doesn't unpack common purpose. A person will simply say, well, they acted in common purpose and leave it at that. But that judgment caused us to literally unpack all the components of the common purpose doctrine. So we worked at it like that, yes. Thank you. Thank you.
Thank you very much, CJ. Maybe just to explain a little bit about co-scribing. It's something that has always been done at the SCA. So it really depends on the presider. So the presider may allocate the matter to one scribe or to two scribes.
Yes.
I've already asked Judge Skippers about a matter where he co-scribed with Justice Wallis back in the day. And in responding to that question, he referred to this one, that he is the one who decided, I think he explained that he's the one who decided that due to the complexity of the matter, there should be two scribes, and he allocated co-scribing duties to you. Thank you, CJ.
Thank you, President. Yes.
Commissioner Mangen.
Thank you, Chief Justice. Good afternoon, Justice Norman.
Good afternoon, Commissioner.
Yes. Mine is it's not really a question, but I would want you to clarify a disconnect that appears on the matter, the reserved matter of Sheriff Giani and Makwibele.
Yes.
In the questionnaire, you gave the date of 19 May 2024 as the date on which the judgment was reserved.
That was an error. I apologize for that.
It was an error. Yeah.
It is an error. Yes.
Okay. The actual date is the 19th of May
2025. That is correct.
Because
Thank you.
The LSSA did pick that up and asked that it be clarified.
Thank you. No, it's 2025, Commissioner.
SAFLI records it as 19 May 2025, which is the correct.
That is correct. Thank you.
So there's no problem with delayed judgment on your part?
No, not at all. Thank you.
Thank you so much. Much appreciated. Thanks,
Thank you,
CJ.
Commissioner. Yes,
You were not at the SCA in 2024, were you? Well, in May 2024 at least.
Yes.
All right. Commissioner Marumakai.
Thank you very much, CJ. Good afternoon, Judge Norman.
Good afternoon, Commissioner.
Most of the times when I read the judgments of the High Court, it appears to me that there are times when the rules of that court are referred to assist in one or more of the matters before the court.
Yes.
It doesn't seem to be the case in as far as the rules of the superior courts are concerned. the cases that I've read, it doesn't seem like the rules are assisting in terms of the things that needs to be done in those courts. And for me, and I'm not saying it's wrong, for me, it brings some curiosity to find out whether the judges of the court that are where those rules are applicable. One, they are aware of those rules, but most importantly, those who aspire to go to that court, they are aware of those rules. So my question is based on that.
Yes.
So now, having said what I've said, when you look at the rules of the Supreme Court of Appeal, in the definitional section, they give you a sense of how you compute the days when you need to operate in that court. They will say you need to use court days.
Yes.
And they give a sense as to how you actually compute court days.
Yes.
And among others, it excludes from 16 December to 15 January.
Yes.
But when you look at the rules in totality, they also refer to things done within a month. And that appears quite a lot. Actually, my counting about 13 times in the rules. And you find that for you to do a leave to appeal to that court, you need to do it within 30 days.
Yes.
I mean, within a month. And it doesn't seem to be clear to me as to how one interprets what a month is and how do you calculate a month. I'm not sure if this is something that you have thought about, and how do we reconcile the computation based on the court dates and this 1 month that appears so much in these rules?
Well, I think when we were taught, I think at university, the reasoning was always that once a month is mentioned in an act, we know automatically it's 30 days. And then if it's a month in terms of the rules, it would be a month in terms of the court rules. But I haven't looked at the definition of a month in the SCA rules.
No, there's no definition. That's where the problem is, yes.
So the 30 days would be the 30 days then. If it talks about a month, it would be the 30 days.
But is that not a problem, though? That perhaps we need clarity as to how, and consistency. Because when you look at the magistrate court rules, it's clear. The rules, in as far as the rules are concerned, the dates, in as far as the rules are concerned, you know, it's court dates. When you're looking at the Magistrate Court Act, you know that you are dealing with court dates.
Yes.
The Superior Court Act also, and the uniform rules, it's also clear. Even in the Constitutional Court, it's also clear. But with these rules of the Supreme Court of Appeal, it appears to be shouldn't there be clarity on actually what we are referring to when we are computing the days of that court, so there's no confusion?
Yes, maybe, but when I used to practice there used to be some rules that would say within 10 court days. But I understand the question that you're asking. I haven't thought about it, but to the extent that it is so, maybe it might need clarity. But I never struggled when I was struggling to understand how to compute them, because I think I must have had reference to somewhere in the rules in order to be able to compute the 30 days or the 10 days within which to file, let's say, an answering affidavit or replying affidavit. But I will have a look at what you're raising. Yes.
Thank you very much, because there's an issue about condonation that comes out of these things, and that's where the
Yes.
confusion is. But thank you very much. Thank you, CJ.
Yes.
Commissioner Gotsa.
Thank you, Chair. Good afternoon, Judge.
Good afternoon, Commissioner.
Sorry, Judge. You described your experience at the SCA acting as enriching and lighting, and you said it was quite a conducive and enabling environment. So I just want to see, or to maybe just clarify, whether that was your overall experience, even in dealing with senior judges.
No, it was until, well, maybe just one uncomfortable experience is when I dissented in one matter where I could see that the judge was really upset that I was going to write a dissenting judgment. But other than that, the collegiality was there, and the manner in which the court is. I mean, the tea room is possibly the size of just slightly smaller than this, and we sit exactly the same way during tea, and you converse with people. So that environment, I think it has changed from what it used to be in the past, because at the time when I served in this body, we had people had a different experience. Yes, thank you.
Thank you.
Thank you, Commissioner.
Commissioner Trolley?
Thank you very much, Chief Justice. Good afternoon.
Good afternoon,
Judge
Commissioner.
Norman.
Yes.
You specialize in maritime law.
Yes.
And it might not include maritime and environmental qualifications, but what are your thoughts about the fact that we are not able to adequately patrol and prevent the exploitation stroke overfishing of our marine resources along our extensive coastline and marine territory? Because it has a direct effect and impact on our economic well-being as a country.
Yes. Well, I think it's because, first of all, the people that practice within that industry, your fishermen are usually people that come from very poor communities. And the regulations, as we know them, they're usually very stringent. And you've got the quotas that apply. And you've got people on the one hand who are desperate for housing, who are desperate for food. On the other hand, you've got the laws that say you cannot fish up to a certain level. So I think for me is one needs to understand exactly where the difficulties are. But those who own vessels, they're thriving in that industry because they're able to get permits. They apply, they get permits. But the question is, how do you then link the people that actually depend on this very industry for their survival? How do you manage it in such a way that there is progression without people breaking the law all the time? And I mean, the Port Elizabeth area, for instance, is rife for abalone theft and all sorts of things that they do there. And in as much as one would say, look, they are doing it, but to enrich themselves because they sell all of this. But it's different when you go to Cape Town, where largely the people that fish there are very poor people that need to do these things or to fish in order for them to survive. So I think the debates, maybe they will have to go back to what the minister had indicated, that the industry, I think it does need some sort of total overhaul. People do not understand, for example, what is it that they could take or they could not take. I don't think there's enough information out there that would alert people as to what they need to do or what they do not need to do. If you go to the areas like Mzamba, the Wild Coast, you will find people along the road carrying fish, and then you ask yourself, they're selling it, it's hot, it's in December. By the time the person buys it, in what state is that fish going to be? So it's all those little things that one has to look at in order to actually look at how best to enrich the industry. Yes.
Thank you. Chief Justice, can I just have a follow-up, please?
Yes.
I know you said we must restrict that. I'm thinking more in terms of exploitation of our marine resources in our marine territorial waters by illegal fishing by foreign vessels.
Yes. No. I hear you. I'm sorry, I missed your question. Well, there are laws for that. We all know what the law is. There's different jurisdictions at sea. You know that from the baseline up to 12 nautical miles, there's a certain jurisdiction that falls within a certain jurisdiction. So the maritime authorities, I think it's called the Maritime Authority, but Transport Authority, Maritime Transport Authority, they are quite aware of those things. And they know exactly why they should be arresting those vessels. I have given orders in Port Elizabeth, arresting vessels for having done the very same issue that you're raising. Yes. Thank you.
Before I forget, this disturbing issue you raised about a colleague who was annoyed because you had given an indication that you were going to write a dissenting judgment. I find that extremely worrisome because that's precisely the kind of behavior that gave that court the bad name you used to enjoy and which we fought so hard to eliminate.
Yes.
I hope you brought that to the president's attention and it was dealt with and dealt with firmly.
No, I didn't. I brought it to the presider's attention.
All right, and it was dealt with.
I think the presider dealt with it, yes. Thank you.
Right.
Thank you, Chief Justice.
Commissioner, Jivan?
Covered, thank you.
You covered. And Steinbeck?
Hi,
Yes.
Judge Norman.
Good afternoon, Commissioner Steinberg.
Sorry about that. There's a peanut gallery behind. I want to engage with you about your dissent in the lion match case.
Yes, yes. Thank you.
Lion match versus SARS.
Yes.
Firstly, the GCB points out that the fact that you dissented is indicative of your independent-mindedness, and I must say that anyone who knows you knows that you're certainly an independent-minded woman and judge.
Yes.
They do, however, say that you erred, and it's not the erring per se that I want to take up with you. It's this. 4 judges wrote a judgment, and it dealt with the tax court and the full bench had both refused a postponement that was brought on the morning of the appeal. The 4 judges went as far as to say that had the tax court granted the postponement, it would have been a travesty of justice. And it quite carefully sets out the facts surrounding the timing of when the applicant, Lion Match, knew that its attorney was withdrawing, who made the affidavit that was before court, and so and so. Your judgment in dissenting engages only with the full court judgment. I don't see, for example, the full court, the affidavit on which you rely. The full court says, well, it was a hearsay affidavit. And clearly it was, because it was a part-time secretary who deposed to it, not the applicant itself. The full court says that it's common cause, that that Lion Match knew about the withdrawal a month before the hearing. You say 10 days, but you don't engage with the reasoning of the court. I'm concerned when I read that, because as the reader of the judgment, you feel like you're in 2 different cases. And I would just like to hear your response. Finally, what was big for the majority was that the attorney was also a director of Lion Match. A lot of your judgment turns on the fact that it was the attorney who pulled out, not the company who fired the attorney. But the attorney is the company, the attorney is a director of the company. And all of these facts are very well laid out in the majority judgment. But you write your judgment as if they're not there. And I just want you to respond to that.
Yes. Thank you, Commissioner. First of all, the appeal itself it lied against the decision of the full court, not against the decision of the tax court. So that is why I addressed the judgment of the full court.
Sorry, you misunderstood me. I was saying, why did you not address what your colleagues in the SCA had said?
Why didn't I?
The majority said, for example,
yes, this
affidavit's hearsay. That is not something you took into account when you relied on the affidavit.
Oh, okay.
That's what I'm referring to. I'm
All right.
sorry if I wasn't clear.
Thank you. All right, thank you. My understanding of the affidavit I relied on is the affidavit from SARS, because that is there. It's part of the record, where the official from SARS says, this matter is a very complex matter. This matter is going to require experts. So I use that affidavit to say, when you're weighing up the reasons for granting a postponement as a tax court, you ought at least to have considered that affidavit, because it was telling you that it's a complex matter, it's going to require experts to deal with it, and I do not see that. The second part of your question is, the inquiry about that matter did not just end at what happened with the withdrawal. It goes further. There is a letter that gets written by the attorney directly to the judge. And that letter finds itself in the judgment that the judge gives. And that letter is written after the matter has proceeded, it has been heard. I think it was sent sometime in December. And that letter is quoted in full by the judge in the judgment. The full court says the act of someone writing to the judge directly is inappropriate. It's there in the full court's judgment. So I'm saying then, in my judgment, if then the full court found that the sending of a letter to a judge is inappropriate, then why not then find that the postponement process as a whole ought not to have happened in the manner in which it happened?
Judge, I'm sorry, it's not really the question I'm asking. The question I'm asking you is, all of the issues you raise are answered and dealt with by the full court. By the 4 judges who wrote the majority judgment. I'm asking whether it isn't appropriate to then engage with how you come to different factual findings.
No,
let alone legal ones.
Yes.
So it's a question of principle.
Yes.
When you dissent, don't you think you should engage with what the majority found?
Yes, thank you. But I did engage with what the majority found in my judgment. Maybe we could go to it, and I'll point out to you where I. Sorry, I just want to find. The lion match is not part of the. Sorry, the lion match is not part of the bundle, but I might have to download it quickly. But I do engage on 2 aspects. For instance, the full court. I'm so sorry. The majority says that the full court was the tax court was correct in saying that. I beg your pardon. The full court was correct in saying that the whole issue of a conflict of interest was a red herring. I deal with that fully. First of all, I say an issue of a conflict of interest between a lawyer and a client is a privileged issue. The tax court and the full court, they say in their judgments, they ought to have been told, when did this conflict arise? What was the nature of the conflict? The details of the conflict. So I say in my judgment, when it comes to a conflict of interest, as practitioners, we all know that a lawyer needs to just stand up and say, my lord or my lady, I'm withdrawing for the matter. There has been a conflict of interest. And I refer to international authorities in that regard. Because it's such a privileged issue, it cannot be expected of a litigant to say, these are the reasons that there was a conflict. And in any event, it was common cause here that the directors of the law firm called in this particular attorney and said to him, we think you must withdraw from this matter. Then the timing becomes critical, and I deal with it in my judgment, because the full court and the majority judgment, they say they knew about it 3 weeks before. Now let's go to how did they get to know about it 3 weeks before. Then I start with what was sent to the litigant, notifying the litigant that we're withdrawing. And I go to that notice and I identify that they relied on the old rule that said, where you withdraw as an attorney, you must do so by sending registered post. So I say, if then it was accepted that that notice was sent, but then the court didn't ask, where is the registered slip? Because that's the only thing that will tell you when it was sent, and we do not have it. So my submission was, my finding was that there were too many issues that that ought not to have been resolved in favor of SARS in that matter. Because if, for example, you say, no, postponing a 10-day trial because your attorney has now withdrawn, that is going to inconvenience the court, inconvenience everyone. But we've got rules that say when you inconvenience me, I penalize you by mulcting you with costs on an attorney and client scale. SARS gets its money, doesn't have to be out of pocket because of that, but also, especially in this particular case, because of the complexity that SARS had acknowledged. Now look at what happened then. In the end, because postponement was refused, then expert evidence was led, could not be cross-examined because the person was affected, and also the nature of the tax issue. The tax issue related to capital gains tax, where shares were valued before the promulgation of the act, but then SARS had to assess them as if, I think there's a certain clause, transitional clause in that act that allowed it to do that. Now, at that point then, it's such a critical matter, such an important matter for any taxpayer that you would want to be heard on it. Now, you don't get heard because your attorney is withdrawn, and you ask for a postponement, yes, belatedly, I understand that, but then you are deprived of an opportunity to place your case before the court. And how then I dealt with how I found that the full court erred. So my understanding is I dealt even with some of the findings of the full court, of the majority in that judgment.
You don't mention the majority judgment once expressly. And their key findings, like the affidavit is hearsay, and that the director is the applicant, and therefore the applicant knew. None of that is engaged with. But I don't think we can particularly.
No, I don't think. Yes, it's a pity because I don't have the judgment here. Yeah, if I had thought I would be asked, I would have brought it. But I do deal with the findings that they make, and maybe
we actually do have the judgment up front here.
You do have it?
We have it, and President Mulemela wants to say something.
Yes, thank you.
Yes, thank you, CJ. We do have the judgment, and there are references to the first judgment. The first reference is at paragraph 55, and that's in relation to the affidavit. And then there's another reference to the first judgment at paragraph 64 and the paragraphs following that one. I'm just responding to the commissioner's statement that there's no reference to the majority judgment even once. It's referred to as the first judgment.
I stand corrected. Thank you, President.
Yes,
Could I just follow up, Chief Justice?
Yes, have you finished, Commissioner Steinberg?
Thank you.
All right, Commissioner Ngwetho?
Good afternoon, Judge Nomia.
Good afternoon, Commissioner Ngwetho.
Yeah, I don't know, when you left the Eastern Cape, maybe you thought you'd be back now. Oh no, where are you, in Bloemfontein? Driving 4 hours to Bloemfontein. Yes. Anyway, I want to ask you this point around a dissenting judgment.
Yes.
Now, forget about this other judgment, Lion Match. I didn't read it, so I don't know much about it. But the judgment I did read is a selective empowerment.
Yes.
Where you wrote for the majority.
Yes.
And it's the same thing I noted, but not by you, but by the dissenting judgment by Judge Kuhn.
Yes.
That you end up with two judgments which diverge from each other. Yes. And reach different conclusions.
Yes.
And it's not the first time I've seen something similar in the Supreme Court of Appeal, where you get a second judgment. It does not explain to the reader what is the point of disagreement. Unlike the judgments of the Constitutional Court, where each judgment engages substantively with where the points of disagreements are, which for me is a very important discipline, because if you did that exercise, you would actually find that there are no points of disagreement, or the points of disagreement are much narrower than it appears. But that selective empowerment case, references your majority judgment once in one paragraph.
Yes.
The rest of the time, it just goes on its own direction. So it made me wonder, what exactly is the process by which judgments are produced by the Supreme Court of Appeal? And is there no scope for colleagues to sit across the table and to say, I see point A this way, I see point B this way, but is there really a disagreement? Or can the two coexist in one judgment?
Yes.
Or whether someone just writes their own and the other writes their own and then they both get published?
No, thank you. There is a coherent system within the SCA. The scribe in that matter of selective was actually Judge Kuhn, Justice Kuhn. He was the scribe. And I then indicated that I was going to write a dissenting judgment in the matter. So then there is a certain process that gets followed. That's where then you get to see that somebody is not happy with you writing a dissenting judgment. He's going to, for instance, if you are a scribe, everything else that, just like in the sheriff's judgment, I think you referred to the sheriff's judgment. In the sheriff's judgment, I was the scribe and there was a dissent to my judgment. But you do everything as a scribe, including even the numbering of paragraphs, including the dissenting judgment, because you are the scribe. That's what I was taught. It's your responsibility. So things happen slightly differently in selective. So you will find that in selective, because a judgment had been written, with me having indicated that I was going to dissent, and then the other judges then went with the dissent that I had written, you'll find that in certain instances, it's, in fact, there's little things that you can notice about that judgment. I refer to him as my brother. Nowhere does he refer to me as my sister. You know, so it's those things that are quite telling. That it's not really an what shall I don't know, an accommodating environment for the dissent, but there is, our judgments are completely different in selective. They are very different. That was one of the reasons that I just had to write a dissenting judgment. But other judges have seen it in the sheriff's judgment, where the other judges accommodate your dissent within that judgment because you are doing, the scribe is doing it. And they'll say, for instance, you don't have to repeat the facts in paragraph 35 because they are contained in the dissent in paragraph 42.
Well, in selective empowerment, they are repeated in both judgments.
That's the thing, yes, yes. So I think it just depends on who you're dissenting, whose judgment you're dissenting to, and how that person accommodates your dissent.
Yes, and also it's odd because the dissent starts, it's the first judgment. That's why I couldn't understand what I was reading. And then when I get to the end, I realize, no, there's another judgment.
Oh.
That's your judgment.
Yes.
And then the two are not speaking to each other. So maybe that's not something you can help because you're trying to get into that court. Maybe when you are there, you can help it.
No, maybe I could just mention that mine, although mine was a dissenting, it ended up being the majority. So because then it ended up being the majority, then it ended up, how shall I put it? Yeah, I think that's what perhaps caused.
That was the cause of annoyance. MBA acting judge managed to sway.
Because what I would have expected is the dissent, at the very least, will say, these are the points that Judge Norman has found. She has misunderstood the record.
Yes.
She has misunderstood the law, etc. Your judgment is just ignored.
Yes. Yes, no, true. Yes, thank you.
Thank you, Sir.
You were the last on the list, then there were all these follow-ups. All right. Judge Norman, it does appear that we've reached the end of your interview.
Thank you. Thank you, Chief Justice.
Thank you very much.
Thank you very much. Thank you to all the commissioners and chief.
before. You know how JSC processes work. More often than
CJ,
not.
I'm having a little bit of difficulty hearing you.
Oh, I was just apologizing for keeping you waiting. We are running behind schedule.
No, thanks, CJ.
Thank you. All right, are you ready to start?
Is everyone?
May we start?
I'm ready to.
All right. You are no stranger to us. You've been here before, so we will try to keep this interview as short as possible. But I do need to reintroduce you to those who may not have watched your previous interview. You hold 5 degrees, to which are 3 directly related to your field of work. You did a BCom and BA honors in industrial sociology at Wits, followed by an MA in sociology of labor studies at the University of Warwick in the UK.
That's correct.
And that one you did on the British Council Scholarship, not so?
Yes.
Okay. How did one get chosen for that scholarship? Did it have anything to do with your merit?
Such a long time ago, but at that time, I don't think I was the only one. There was quite a lot of students, South Africans, who got British Council's scholarships. There were also US aid scholarships that were available at the time, if I remember. I chose to go to Britain. I was invited by one of my lecturers or somebody to apply. And I did, and it worked.
But then your competence would have had something to do with it. Not everyone was. It was not just thrown at everyone who wanted it.
Obviously, yes. Obviously, you had to meet the criteria.
Yes.
So yes.
Then you did an LLM in labor law at Wits again.
Yes, before I did the LLB.
I wanted to ask about that. Then thereafter you did an LLB. How did it work?
It was strange because I had already been a lecturer in sociology at Wits at the time. So I knew some of those people. I then applied for the LLM, got in, worked with the LLM. I worked with Edwin Cameron. He was my supervisor. And the dean at the time was Carol Lewis, both of whom were judges, you'll be aware. And they said, yeah, you can. Carol Lewis said, yes, you can do both. Why not? And so we did it. And we ended up doing it.
All right. Speaking about your tenure as a lecturer, it was at Wits.
Yes.
You taught medical, you tutored in medical sociology.
I tutored in medical, yes.
And was a junior lecturer. You did well as a tutor, so they promoted you. You also had a brief stint in the labor field. Did you work for a trade union, Kausa?
Yes, commercial catering and allied workers union.
But that was for.
They still exist. They call South African Commercial Catering.
Oh, all right.
And they still operate in the Pick and Pays and the Woolworths and.
All right. Then from that experience followed your work at IMSA as a mediator, proprietor, senior commissioner at the CCMA, and then you went to the bar in 1996?
Correct.
And took silk in 2010?
Yes, correct.
In the same year, you started acting as a judge?
Correct.
In Johannesburg? And you were appointed, you acted for a short stint?
Correct.
Just 1 month, and then boom, in May 2012, you got your permanent appointment?
Correct.
Okay. You've acted as a judge of appeal at the Competition Appeal Court. You've had number of stints there, and you also acted at the SCA.
Yes.
In the last term of 2024 until the second term of 2025. So it's 3 terms?
2 terms.
Or just 2? Oh yeah, December 2024 to May 2025. It's 2 terms. So you do have a fair amount of experience at the appellate court.
I do, yes. And if you count appeals in 3 benches as appellate court, then of course,
yeah,
it's a bit more, yes.
Have you written any judgments at the CAC?
Yes, I did.
How many?
I've written 3.
Mm-hmm.
I was scribed for 4, but 1 collapsed on the morning.
All right. And at the SCA in those 2 terms?
Yes, I've written 3 judgments.
3. Okay. You list a host of involvements in quasi-judicial roles. I'm not going to go into those, but more interesting for me is the fact that in the midst of everything you do, you found time to publish a book, A Social Contract. But that was some time before you became a judge.
Yes. It was an interesting topic at the time. It was an important topic at the time. It was pre-1996. And a lot of the debates that were going on at that stage was what should be the approach, what approach should our country adopt? And the organizations I had contact with and was involved in was concerned with that topic. So I sat down and wrote my thoughts, did some research and wrote my thoughts.
Yeah. And you have written an article in that field and a couple more in labor law.
Yes. I've also written, I think, an article on in sociology.
Let's see. I did promise that the interview would be fairly short. Now I'm trying to see if I can live up to that promise.
Short.
How old are you now?
66.
66. So you still have a good few more years to serve if you are elevated to that court.
Yes.
All right. I will let you go and hand over to President Mulemela, whose court you want to join, and the rest of the commissioners.
Thank you, CJ.
Good afternoon, Judge Valley.
Good afternoon. I'm having a bit of difficulty hearing, so I'm appreciating.
Oh yeah, the acoustics are not particularly good here.
Good afternoon, President Mulemela.
Yes, how are you?
I'm well, thank you.
All right. You had an opportunity to act as a justice of the Supreme Court of Appeal for 2 terms.
Yes.
How was the transition from being a judge of the High Court to being a justice of the Supreme Court?
The transition, I wouldn't say was too difficult. But the experience was very interesting and very valuable. But the transition, I didn't have too much difficulty. I don't know why, but it came quite natural. It was quite easy. For a start, let's talk of the social. I thought, I'm going to have difficulties living in Bloemfontein. I was pleasantly surprised, very pleasantly surprised. It's nowhere near as bad as I thought. In fact, it was very good.
I'm glad to hear that.
Bloemfontein is quite good. I mean, there's a lot going for you in Bloemfontein. And I found that
I fully agree with you.
You fully agree with me.
So, you informed sorry, did I cut? Did you still want to add?
No, I had nothing to say.
All right. Okay, so you told the Chief Justice you wrote 3 judgments at the SCA. What was the turnaround time?
Turnaround time. All my judgments were written as before I left. In other words, before the term was over. All my judgments. When I was previously interviewed, I do recall very clearly the Chief Justice asking me about work pace and telling me that there was a convention that you must finish your judgments in the term in which you sit. And I thought that convention still applied, so I worked sure I wrote all my judgments before I left. All of them. Before we packed my bags, they were either out to the rest of the panel, or at least they were out to a researcher who then sent it out, brought it back in a day or 2 or 3 days later it had to go.
Yes, I do remember that the day before the term, you came to me and you said exactly what you have just said now, that they are in a stage of being finalized. So I'm happy to hear that they were finalized soon thereafter. So you have no reserved judgment.
I do. There
From
is
the
a
SCA?
reserved judgment. No, there is a reserved judgment.
Okay.
No, there is. What has happened there, after I've written my judgment, then other panel members had looked at it. Another panel member decided to write a different judgment. That took some time. That has come out. But a third judge now has decided that she wants to write another judgment. So we're waiting for a third judgment. So, and I don't know, and the fourth judge, I don't know what's going to happen there. So, yeah, it was an interesting question.
Yes, but yours was...
And the panel's working through it. And the fact that we have so many judgments would make it a very interesting conference and a very interesting. Whether we end up with only one judgment or not, I don't know. It would be nice if we do, but we're working on it as a team. So it's not only up to me.
Yes, I understand the process, but your own judgment, you circulated it timelessly.
I've circulated it a long time.
Thank you. Thank you very much, Judge Valley. Thank you, CJ.
Thank you, President. Commissioner Matolo Dlebo.
Thank you, Chief Justice. Good afternoon, Judge Valley.
Good afternoon.
I'm here.
I'm here.
Yeah.
Sorry, thank you.
I think mine is not a question, but just a comment. I just want to hear your opinion regarding, you are an experienced mediator, and remember when we were still at IMSA, you used to coach us on mediation.
I used to?
Coach us on mediation at IMSA.
Thank you.
Yes, but what I wanted to find out, because there's this court, now there's a directive that parties must go for mediation.
Yes.
Have you, and mediation being a voluntary process, you know,
yes.
Do you think it's working in an environment, or do you think it has a potential of delaying matters going to court? I just wanted your opinion.
I think it's an exceptionally good question. I don't think, remember when we worked at IMSA, mediation was voluntary. We chose it and we decided that we want mediation. And it came out of my experience as a trade unionist. We were the ones who pushed for it in the workplace. Forcing mediation on the parties as is happening here, I understand the logic. The logic is that a lot of people are settling at the door of court, particularly in the very busy road accident fund cases that we receive in our court, the very busy court. I've seen a lot of problems in the last term, a lot of complaints by parties saying this is simply just another route for us to follow, but we're going to still come back. And I've got a lot of applications in an unopposed court compelling a party to come to mediation because that party is delaying and not willing to comply with the practice directive. It's very, very young at this stage. How it's going to pan out, I don't know. I hope that it will work. If it works, it's to the benefit of litigants, it's to the benefit of the court. We are, I must say, inundated in that court. And whether this was an act of desperation, I don't know. I don't think so. But we need to do something. We can't have a situation, quite honestly, we can't have a situation where litigants must wait 5 to 7 years before they can get a trial date. By that stage, things can be very difficult. So yes, I agree with you. The experience is a bit mixed at the moment. It's too young to say whether it will last. There is a problem with financing of the mediation. When we did it in IMSA, remember there was a lot of funds coming from overseas. And we could use a lot of those funds for mediation. So a lot of unions, like my union, was getting money to assist us in these things, and we used it. We paid for mediators and things. IMSA also got money like that. It's a bit more different now. What it costs, etc., I don't know. So to answer your question, I would hope it works, but I see problems already arising. And hopefully we'll iron them out in time.
Thank you, CJ.
Thank you very much, CJ. Good afternoon, Justice Vali.
Good afternoon, Commissioner.
Okay. No, thank you very much. I took interest as well in your work more around your publications and also your book that shows more strength in terms of industrial sociology.
Yes.
In looking at today's work and your background in terms of union work and all that, how do you think we should be able to help the country in balancing the interest of investment versus participatory democracy, especially taking your strength or your area of work, such as on mediation, in dealing with labor movements in the country?
Thank you for that question. It's a very interesting question. And it's not easy for a judge to comment on political issues and or other social issues, especially when some of them may come up before me in one form or another. But I do believe that my strength and my experience as a mediator has taught me that there's a lot of room for dealing with some of the conflicts we find, particularly with regard to demands by the investors and the demands of the populace and demands on the country as a whole to attend to some of our very deep social problems. And they sometimes do come into conflict with each other. And I think through mediation we'll be able to, hopefully can resolve them. I know we have a body that was working through that. It's called NEDLAC, if I'm right. And it's supposed to be working through that problem from the very beginning. That was our intention, those ideas, and I'm hoping they work. They sort of. I'm led to believe that they have done excellent work, and they have managed to resolve many difficult issues over time. So yes, and in fact, I'm hoping that that benefit can seep through every other area. In fact, right now we have a government of national unity. I'm sure they're going to benefit from the ideas, the learnings, the experiences that comes out of that process.
Thanks a lot. I don't think it's political, Judge Vali. It's
accept
more
it.
around
I'll agree with you.
the role, because I do believe that the judge and the courts do have a role to contribute towards socio-economic development in the country.
I fully agree with that.
And therefore, we all have to make sure that all that sharing and taking that responsibility. So I thought I should just give you assurance that I'm not coming from a political.
No. And I misunderstood your question, but I certainly agree with everything you say. And I certainly take an approach that we must, as courts, not remain aloof. We must not remain in an ivory tower. We must understand the difficulties and sufferings, and we must be sensitive to them, and we must bring it into our work. And I believe I have definitely done that. That I have no doubt about.
Thank you.
Commissioner Mangen, followed by Marumafai.
Thank you, Chief Justice. I'm here.
Sorry.
On your left.
Thank you. Thank you.
Good afternoon, Justice.
Good afternoon, Commissioner.
Yes, I wanted to commend you for the judgment that you wrote on Resilient Rock versus Voltex.
Oh, yes.
The judgment that dealt with Section 3475 of the Companies Act, the winding
Yes.
up. Whether two orders can coexist.
Yes.
A final order while there is a provisional order pending. And that judgment provided clarity that it is not possible or competent to have two liquidation orders coexisting at the same time. But thank you very much. With regard to the question that I have for you, you have remarked that there is a judgment that's pending where other judges have indicated their desire to write their separate judgments after you have written yours and you are describing that judgment. My question to you is, since you are an acting judge there, are you of the view, or have you experienced intellectual bullying in the SCA?
Intellectual bullying?
Yeah. Did you at any stage feel like you are being undermined because of where you come from and the depth of your intellectual ability to deliver judgments and the understanding of the law?
I wouldn't call it bullying, but we did have some robust discussions in conferences. We've had robust discussions, and people have to justify the positions they take. And I found that quite challenging. I found the way they work slightly different from what I was used to. And yes, I found it very exciting in that sense. But bullied, no, I don't think so. It will be a bit difficult. I think we are all we're all intellectuals that respected each other. And I don't think anyone there would be able to say to me or me to say to anyone else that you don't know what you're talking about or you were. I understand that may have been a practice before. I don't know about it. I wasn't there. But no, I don't find intellectual bullying. I didn't. But some people may have found it difficult. I can't speak for their experiences, but not my experience wasn't that.
Thank you, Judge.
Thank
you, CJ.
Prof?
Thank you, CJ. Good afternoon, Judge Valley.
Good afternoon.
At
least I can see you quickly. I'm looking around for everyone.
No, thank you very much. I'm in a process of trying to establish whether the judges who have ambition to serve this country at the Supreme Court of Appeal, whether they are looking at the rules, they are thinking about the rules, and some of the legislative provisions that make that code work. And my question is based on what I've just said now. Last year, there was an amendment to the Superior Court Act, and in particular Section 17(2)(f) that deals with the reconsideration of decisions to dismiss leave to appeal in the Supreme Court of Appeal. I'm not sure if you are aware of that and the changes that were brought by those amendments. If you are, can you prefer some words on those changes?
Well, Section 17(2)(f) was the subject of a lengthy discussion by the judges of the Supreme Court of Appeal, and I was privileged to be part of that discussion. And I was also in a judgment in a case where 17(2)(f) was considered. And so, yes, I know about the issues. I know about the debates around it. I'm aware of the debate, and I'm aware of how the judges are busy dealing with that issue.
I think the debates are important,
Sure.
and one cannot trivialize them. But I think my question is more on what legislatively took place, because there was a particular test that was used for somebody to ask for reconsideration by the president of that court. And last year we saw a change in the test, and that's what I'm trying to probe, whether you are aware of the changes in the legislation with respect to that particular provision.
Yes. If you're referring to that on exceptional circumstances, position that the president may, on exceptional circumstances, call for reconsideration. They made it a little bit more difficult, if I'm correct. But we do get a lot of those applications that still say they have met the test, they've met the threshold. And yes, it is difficult. You must bear in mind that the legislature is trying to work through a problem where everybody by this stage has brought another application for leave to appeal, having failed at the first court, having failed by the two bench in the Supreme Court of Appeal, and now for the third one. And the legislatures had to bring some sort of control and order in there. So I'm aware of that. And I think the legislation brought something good by asking for it to be on exceptional circumstances. But how it's going to fully pan out, I can't say in time. Because as I said to you, there's been robust discussions about it.
No, thank you very much. I will leave it there, but I think it might benefit you to look at what was done, because originally the test was exceptional circumstances, and that particular test has been revised to some extent. But in your time, you should be able to look at it. Thank you very much, CJ.
Commissioner
Thank you
Hassan?
for that. Thank you for that advice.
Thank you, CJ. Commissioner Hassan over here. Judge Valley, in your own jurisprudence, you've wrestled quite a bit with the tension between transparency, freedom, and the harm that speech could cause. Particularly in the SANF versus the Minister of State Security case in 2019, you wrote that transparency is the lifeblood of democracy and secrecy is its poison. That's at paragraph 67. And you actually struck down provisions that criminalized publications about national key points. And those are quite powerful affirmations of an open democracy. But we're now in an era of algorithmic amplification, disinformation, hate-driven online, not only speech, but mobilization. And we're seeing this not only in South Africa, but the world over. So my first question is around your thoughts on how courts could or should refine the constitutional test under Section 16 of the Bill of Rights to ensure that freedom of expression continues to protect that robust democratic discussion and debate, while also guarding against speech that's dehumanizing, insightful, and endangering different interest groups. Thank you.
The issue is going to be alive for some time. Hate speech has unfortunately become quite prevalent the world over. At the same time, one cannot deny that there's also been a move to silence voices that one doesn't agree with. In Britain, they're struggling with this issue very strongly. They've prohibited an organization, and anyone who's in support of that organization is now finding themselves on the wrong side of the law. So it's going to be an issue with us for a long, long time. There is a lot of hate speech out there. There's a lot of painful speech. And I genuinely believe that speech matters, words matter. I genuinely believe that words matter, and it can cause significant harm. So yes, we're going to have to be careful about just saying we'll allow everyone to say whatever they feel like saying. We can't. We don't in this country anyway. We certainly don't. We don't allow speech. A lot of people have gone to prison for using, not a lot, but at least some people have gone to prison for using hate speech. We come from a history where there's been derogatory language used to describe certain people. We can't tolerate that. So while I on the one hand say, yes, it is the lifeblood, as I think what you quoted, it's the lifeblood of a democracy. I'm not naive enough to say that you can say what you feel like saying. I will never allow that. I will never tolerate that. I will silence it quickly, wherever I can, whenever I can. And if I have to do it while I'm on the bench, I'll do it. I have no fear or favor in that regard. And I have a position. I don't believe in absolute free speech. I don't. There is no such a thing. There can be no such a thing. Because that causes so much harm. You can't. And I don't think any sensible democracy or sensible society can follow that rule.
So let me then follow with this, Judge Valley. Do you think or believe that our current jurisprudence, particularly on bona fide political expression and the harm principle, is it still fit for purpose in this digital age, or do you think it requires some further development or refining at the appellate level?
Do you know, Commissioner, is it Hassan? Do you know, Commissioner Hassan, we're living through a time where there's lots of changes taking place. And if you're referring to what's happening through this AI processes, you are. I see you nodding your head.
Well, it's a combination. It's AI. It's also been the fake news that really disseminates in the country. We were recently victims of an international, I would say, fake news sort of attack on the white genocide, et cetera, et cetera. So it's all encompassing, and I just worry whether our jurisprudence is moving as fast as it should to not only protect the state, but more importantly, protect our people.
Commissioner Hassan, it's not an issue judges or courts are going to be able to resolve on their own. There's going to have to be legislative intervention. And all the parliamentarians sitting here will have to look at the situation carefully. And parliamentarians may have to look at what they want to do. Judiciary cannot solve all our problems and will not solve all our problems. We must understand that. That's why we have three arms of government. And the legislature have a limited role, an important role, and a special role to play. And the judiciary have a separate role to play. But together, we will certainly be able to address this problem of hate speech, of false allegations, and they're harmful, they're very harmful. The one you just mentioned really harmed us. And I'm not naive about that. And I won't allow speech like if somebody came and they brought an application, an interdict to say that, then I will explain why I would grant an interdict on something like that. I wouldn't have too much difficulty when I see it harm. So, but it's not an issue. I genuinely don't believe it's an issue that courts are going to resolve by themselves. There's no way courts are going to be able to do that. There is legislation in place. Courts will apply that. Courts will probably develop the law. Will have to develop the law on some of that. But that's as far as courts can go. Legislature must then take over. Or in fact, should already start taking over. But I don't know. I don't know. I can't take it further than that.
Okay. All right. Just two aspects from me, Judge Valley,
thank you.
In front of you. I had hoped that the members of the professions would raise them with you. Maybe they were raised and I missed it. You'll tell me if I did. The GCB deals at length with the judgments, the 6 judgments you have listed in your questionnaire, which were overturned by the SCA, and they do a thorough analysis of your reasoning and so on. But at the end of it all, they return an assessment that your judgments are generally well-reasoned, and they extol your independent mindedness. Then they deal with the negative comments that had been made against you for your previous candidature for another position, and they dismiss those. They say those views are not generally held by the relevant people. But then there is one aspect they say at the end of their commentary, which I find a bit worrisome. They point out that you have a knack of sometimes disregarding precedent, which they say, and one would be inclined to agree with that failure to follow precedent may be interpreted by the public as a disregard for the rule of law. Are there any judgments of yours which have disregarded precedent, and what do you think of the authority of the doctrine of precedent?
Oh, certainly, stare decisis is important for the principle of the rule of law. Absolutely. It brings certainty, and certainty is important for litigants, it's important for courts. So without doubt, stare decisis has stood the test of time and should continue to be applied. So there's no There's no debate about that. The allegation or the criticism that I didn't follow precedent, it's a little bit more complicated than that. They're referring to one particular, if they're referring to the one particular judgment I wrote with regard to contract, in which I believed that the Constitutional Court had moved in the direction towards reasonableness, fairness, but most important of all, good faith. And I then applied it, and I wrote a judgment, a minority judgment on that, in which I said, I'm following Constitutional Court principles. Since then, another Constitutional Court judgment came out. It's the famous one called Biedeka, and it has clarified the situation. There was a division there. My position was supported by the minority judgment of Froneman J, supported by Madlanga J, and then there was another minority judgment by Victor J, which took the same position. But I recognize that what the judgment that criticized me said was correct, and that was that I had assumed, and I had followed the approach that good faith can be a self-standing approach in principle, and Biedeka has made it quite clear that that's not correct. So I've learned from that. I've learned from that criticism. I understood the Concord to be going the other way, but Biedeka said it didn't. Now that came after me. But to say that I just disregard it because I don't like it, or I don't like the outcome because I don't think it's just, I don't think that's correct. I've many times followed precedent, which in my view might resulted in not the kind of justice I would have liked, but that's the law. There's nothing I can do about that.
Many times or all the times?
Oh, I think all times. I follow all the times. In that position I took there, I believed that that was our law based on Constitutional Court judgments of, in particular, Parkhazen, Everfresh. There was a few of them, Botha versus Rich. There was a few of them that came out. But there was a tension, and I noticed that tension between a Supreme Court of Appeal judgment called Bredenkamp and those cases. And I deal with that in my judgment. And there was also other Supreme Court of Appeal judgments called Brisley versus Trotsky. There were so many of them.
Yeah.
Afrox Healthcare, I think, was another one. There were so many of them. And I went through all of them. One thing I do, Chief Justice, is I don't just pick things out of the sky and out of my head. I do my research, and I do it thoroughly.
And you do accept that you are bound by
and precedent. I am bound by precedent.
Okay.
I will definitely believe I'm bound by precedent. Whether I like the precedent or not is irrelevant.
Indeed.
Indeed, it's irrelevant. If I want to change it, I must be sitting in the right court, and that's where I must be making my point. If I'm not, I'm bound by what they say.
All right. Well, that's as unequivocal as I can't ask for more.
Thank you.
Then just one last issue raised by, is it the BLA? I think it's the BLA, which says those who practice in Gauteng hold a view that he does not have a good work ethic and often refuses to certify matters trial ready for what they suspect is an inclination to do as less work as possible. Do you have anything to say about that?
There's no truth to that.
But
I do take a hard line on certifications. But I think there's a there's probably going to be a misunderstanding here. Let's understand what certification is. In the Gauteng High Court, at one stage, we set up what was called a certification court because everybody was coming to court when their matters were not ripe for hearing. They hadn't completed discovery, they haven't completed further particulars, they haven't done it, but they got a trial date. We must provide them with a judge, and then these things are not ready. So we set up a court which said we must certify them for trial readiness before they can get a trial date. It's all part and parcel of trying to control the proceedings of the court. When I went into that court, I told them, if you're not ready, there's no purpose for us to reserve a judge for you. We can't do those things. Our courts will. So I'm not even the judge. When I don't certify, I'm not even the judge that hears it. I just simply don't allow you to get a date. And I'm saying you're not going to get a date unless you're ready. So I don't know why they say that. And in terms of work ethic, I don't think this.
That's what I'm more interested in. Are you a lazy judge? Because in essence, that's what they're saying.
Everybody else, in every other comment you have received before you, says the exact opposite.
True
Exact
that.
opposite. I have worked extra hours all the time. If there's anyone who can say that with a straight face to me, I would simply say to them they need to rethink.
Thank you, Judge Valley. That's the end of your interview.
Is that the end of my interview?
It is.
Wow, that was quick. Thank you very much, everybody. Thank you for the opportunity. And before I leave, can I just say thank you to Judge President Moemela for giving me the opportunity. Can I also say thank you to Judge President Moemela for giving me the opportunity to act in that court and to experience that court which I'm now applying for.
You're
Thank you
most
all for
welcome.
your time, and I wish you all the best in your deliberations.
Thank you, Judge Valley. You're excused. Good afternoon, Judge Windel. How are you? Fine, thanks. I see that we are both dressed in black.
Yes, I saw that.
We were supposed to interview you 2 hours ago already. We do apologize for keeping you waiting.
No, that's no problem. Thank you, CJ.
Thank you for your understanding. Shall we go then? Are you ready?
Yes.
Okay. You have 2 law degrees at BURIS from Northwest University and an LLB from UNISA.
That's correct.
Okay. You came through the ranks of public service. You started as a prosecutor in 1989 and remained with what you call the NPA now until 1993. So that's 4 years.
Yes,
Then you joined the magistracy.
that is correct.
How long were you a magistrate? 20 years.
20 years,
You were a
yes.
magistrate. So that your term there started in 1993 until 2013, and then you had started acting as a judge from 2011.
Yes, 2011.
Which continued until 2013 when you finally got a permanent appointment.
That is correct.
All right. So you have been a judge for how many years? 12 years?
12 years. This
Yeah.
is my 13th year.
And you have acted in this court to which you seek appointment, the Supreme Court of Appeal.
Yes, I've acted 4 terms. I started in 2022. Then I had 2 terms. Then I was invited back in 2023, and then again in this year, 2025.
So how many terms does that make it? 4?
4 terms.
It's a year. It's a long time. And I'll leave that to President Mulemela. I know you mostly from the South African chapter of the International Association of Women Judges. I know how passionate you are about the women's cause and mentoring of young and upcoming lawyers and judges. Are you still involved in that kind of work?
Yes, I've been a mentor to many students this year, students that came to shadow me. I'm part of the Bridget Mabandla mentorship program. I had somebody that I mentored there. I'm also involved in training of aspirant judges, aspirant magistrates. So that has formed part of my duties as a High Court judge. When I was a magistrate, I had more time to go into the community and also mentor their students at the university, as well as going out to the community to inform them of their rights. But unfortunately, being a High Court judge, your time is limited.
Yes.
So that's the way that I'm giving back.
But you have managed to produce good judgments.
Thank you,
with
CJ.
all of that going on. How many have you written in the High Court?
Well, I've had the same secretary now for 13 years, so she has kept files in her office of my
I saw a
judgments.
staggering figure of 440.
Yes, we actually counted them. So it's a lot of judgment, but it's because of being part of the Gauteng High Court. You know, in one term you will easily pick up between 20, sometimes 20 judgments in the course of 3 weeks. So you learn how you have to work fast and get them done.
Yeah, I admire colleagues in that court. I don't know how you manage. So, any of those judgments reported?
I've counted. I've got 11 reported judgments as far as I could see. I've listed them, I think, some of them in my CV and my questionnaire.
You have. You've written at the SA as well.
Yes, I have. In my 4 terms, I produced 2 judgments per term. 5 of them have been reported. Yes, so I've produced two judgments per term.
You've done significant amount of work in the tax court, according to your application papers.
Yes, I've for the first time when I was appointed as a judge, I was allocated duties in the tax court. The first time I went there, I was completely overwhelmed. But then I actually found it quite interesting. You know, tax law is one of those areas of the law where you can really go into the nitty-gritty of the act and interpret certain sections. So I actually found that very challenging, but also rewarding. And I produced 1 judgment in the SCA that dealt with tax matters.
So your experience down below came in very handy, I'm sure.
It did.
All right. You had a lecturing stint earlier on in your career at your alma mater?
Yes, I did. I was involved in that was in my 20s and 30s. I was involved at the Northwest University, and I also lectured at the LEAD. What is that? The Legal Education. Can't now remember what it stands for, but I was involved with that for a couple of years.
So that's where your passion for mentoring and all that comes from.
Yes. Sorry, when I get nervous, my nose starts running. So just
Take your time. And you don't have to be nervous. You're in good hands.
Thank you, CJ.
All right. I'm going to hand over to the commission to put questions to you, starting with President Mulemela.
Thank you,
court
CJ.
you wish to invade.
Good afternoon, Justice Wenda.
Good afternoon, President Mulemela.
How are you?
I'm very well, and you?
I'm well, thank you very much. The CJ has already covered a lot of ground. Just for me to mention that you were here before, and subsequent to that, you had an opportunity to act again at the SCA.
Yes, which I would like to thank you for that opportunity to go back earlier this year, because I think one of the comments from the DP at that stage was that it felt that I needed more experience in the SCA and was granted that opportunity. Thank you for that.
Yes, and how did you find the working environment in your last stint?
I actually enjoyed it very much this time around. I think for me, I found my place at the SCA. I knew most of the colleagues there. The work environment I felt is so conducive, to actually just sit down and deal with your judgments. Everybody's got the same work ethic. You've got the time to read your papers. So I think this time around, I found it very pleasurable. So thank you for that.
And in terms of your turnaround time for handing down judgments?
Well, the last term I produced my first judgment before I left. After that was within 6 weeks, and my second one I finished just after I left the SCA when I was back at the High Court. That was within 2 months.
Yes, thank you very much. Thank you, Justice Wenda.
Thank you very much. Good afternoon, Justice Wenda, Judge Wenda.
Good afternoon, Minister.
How are you?
I'm very well, and you?
I'm okay. I'm following on the work that you do in terms of mentoring and training and the support that you do for those upcoming, but also having had a window of the work that is done by the International Association of Women Judges earlier this year, its significance, and listening to some of the delegates there, it's quite remarkable that this work is done. Just to go into that area, what do you think should be done to encourage more women to come to the bench, to participate, but also within the sector, because there's quite a lot of issue that raises that you do find them coming out of universities, and some actually make it as juniors, but never survives to reach the point where you are. Being in the space of mentoring and training, what are you pulling or what are you picking up as issues that we as a country need to deal with to be able to ensure that more women do make it to the bench?
I think a lot has been done in the last couple of years. My experience is that when you go to, for example, interlocutory court, unopposed motion court, 90% of the litigants, not the litigants, the counsel that appear in front of me are women. It is more issue when I think one gets to more complicated cases, high-profile cases, that one still gets that it is men, mostly men that appear in front of us, and especially white men. So I think to encourage is by giving, being an example, seeing what can be done. I moved through the ranks as a prosecutor, then a magistrate for 20 years. And I think that is what we need to do. We need to be a role model for women and explain to them and show them that it can indeed be done.
Thank you.
Minister, Commissioner Moiman?
Thank you, CJ. Good afternoon, Judge.
Good afternoon, Commissioner.
Thank you. Welcome back. Following your last appearance here in May 2024, one of the judgment that you penned is dealt with the security of extension of security of tenure.
Yes.
Yes. Now, one of the challenges that we have in our countries is dualism in the property regime.
Yes.
Particularly as it pertains to the communal land occupiers vis-a-vis the urban dwellers. The urban dwellers will enjoy certificate of ownership and security of tenure. And now in relation to the communal land occupiers that find themselves under the institution of traditional leadership, they do not have that. Ownership in terms of the communal land, in terms of the Agricultural Land Act, vests in the Minister of Agriculture. So now, given this judgment, it will be interesting to get a sense from yourselves what could be done in terms of extending the security of tenure to those. I'm sitting next to my chief here, who mainly are the leaders of those communal land occupiers. What could be done in terms of property right clause in the Constitution to even extend the security of tenure and the certificate of ownership to those communal land dwellers?
I can only speak to the judgment that I've penned during the earlier part of this year. That was the judgment of, I think it was Pieterse, that dealt with ESTA specifically. So I've never dealt with the question that you've posed to me now. But if I can venture an answer, I would say that there would be an interplay between customary law and common law. And when we go to the community where that is their norm, that is the way that they are living, that is the customary way of living, one should then apply the customary law to those type of scenarios. I've never thought about what the answer would be. I've not had a case like that. But I would think that customary law would play a very big role when one would assess land rights. What does the community want in those circumstances? Does it comply with the Constitution? So that would be some of the aspects that I would consider. But unfortunately, as I've indicated to you, I've not had the opportunity to really think about it and do some research on that topic.
Thank you, Judge. Thank you, CJ.
Professor Marumugai?
Thank you very much, CJ. Good afternoon, Judge Wendell.
Good afternoon, Professor Marumugai.
I'm in a process of trying to find out whether the hopefuls who are wishing to serve this country at the second highest court in the country are aware of the systems and the processes of that court. I'm particularly concerned about applications for leave to appeal and applications for reconsideration, those sort of matters. I'm not really sure if you have thought about this. If you have not, then that's fine. I just want your view on it. It seems to me when I read the rules of that code, it is really not as easy to comply when you want to set up the record. To an extent that it appears to me that the process of making the record, it has been commercialized. In other words, for you to be able to comply, if you get a correspondence in Bloemfontein, they will say, can you please get this company that can compile the record? Because the judges want the record to be in this way. And you might find that the way in which the convention is like is not necessarily stated in the rules. I'm not sure if it's something that you are aware of, or maybe I'm just raising a non-issue. Is there something that you can comment on?
I think when one deals with, are you talking about petitions specifically?
Yes.
Petitions. Petitions must come in a specific form because one would receive on a Tuesday maybe 2, sometimes even 3 petitions. You have to set everything aside and immediately deal with it. So it's so important that there is some sort of format in which those petitions are placed before you. You can just imagine if every person just file papers as they deem fit. So that's why there is a limit on the papers that needs to be must be filed. There is a limit to the volume of the papers that must be filed, and it must be in a certain format. I mean, you must share the frustration when you sometimes get litigants that do not comply with the rules and they file papers in the way that they seem fit. And it's very difficult then, in that short space of time, to actually get to the point, because that's what you need to do. You need to know this is the application, this is the founding papers, these are the answering papers, there I will find the judgment and the leave to appeal judgment. So there must be some structure in filing the papers. I don't know whether...
No, that is helpful, but I think where I'm getting at is understanding that structure, because it is easier for the usual suspect who litigate in that court to know the convention. But if the convention is not in the rules and there is no, because usually the president of the court will give some directive as to how, if something is not in the rules, as to how something must be done. So if a record has to look in a particular way, and when you read the rules, it doesn't give direction as to how it should be. So in other words, if you are a small firm from whatever, it's for the first time that you're litigating in that court, you don't know the convention. So it becomes difficult for you to comply with the convention, not the rules, because the rules are not necessarily as enlightening as to how the record should be. I think that is the concern that I'm raising. But obviously it's not your problem. I'm just highlighting it.
I share your concern. We get a lot of matters on petition where it's unrepresented litigants that also file their own papers. And of course, then you would be more flexible because you know this is an unrepresented litigant. So you would condone basically the non-compliance with the rules. In the end, we need to know what is the position. There must be a judgment. There must be some reason why you want to take this matter on appeal. And I think one would bend the rules a bit when it comes to that, especially when it's somebody that don't litigate in the Supreme Court of Appeal on a regular basis.
Thank you very much, Judge Wendell. Thank you, CJ.
Commissioner Mnugaito.
Thank you, Chief Justice. Good afternoon, Judge Wendell.
Good afternoon, Advocate Nkatobi.
Yes, so I was very keen on your judgment on Peters versus Stemmet, because of my concern that despite having a good constitution, it is producing anti-poor outcomes. But the judgment, I think, shows what can be done with a good constitution. Because when you look at the primary facts of that case, of occupiers that have lived on a property that is neither rural nor urban, and it is somewhere in the middle, they do not enjoy the protections of Esther. But at the same time, they must be evicted under PI.
Yes.
And so they are in the middle of nowhere. But I think what is remarkable with your judgment is that its starting point is not the sort of technical wording of the statute. Its starting point is the purpose behind the statute. The purpose, in fact, that is what appears in the very opening paragraph. That Esther was intended to extend protection to vulnerable people who otherwise would be without a home or without a place of residence. And you do so even in the context where ownership of the property has changed. And the new owner says, I don't know these people that are living here. You know? And so there is something powerful there about the judicial encroachment into the absolute nature of private property. So I wonder if that is something that we can extend to other areas. And the reason I got interested in it is because there was another case on cattle decided by the Supreme Court of Appeal, which went the opposite direction.
I saw that, yes.
So I wonder whether there is scope here to develop this line of reasoning into other spheres in order to make real the promises in the Constitution.
I'm sure
We can
there
think
would
about
be.
contracts, for instance.
Yes.
We can think about other forms of property other than land.
Yes, I think our whole lives is actually based on contract. Everything that we do every single day, everything is a contract. Going back to the matter in Esther, we had some vigorous debates about that matter. And at one stage, we had a split decision. But in the end, we managed to get together and we produced one judgment. And I think one needs to, as a judge, give effect to Esther and the constitutional values entrenched in it. And we have to find ways, because it's easy to say we've got a constitution, but then when you interpret law and you interpret acts, you go strictly to words and you forget about the constitution. You say this is not a constitutional matter. So what makes it easy with Esther is we know that we have to comply with the constitution, and that it has to be interpreted with the viewpoint of the constitution. So I'm sure if we talk about contracts, we know that the Constitutional Court has had the last word on contract, but I think there was a door left open to say that we haven't had the specific facts yet that might open the door for expanding the issue as far as contracts are concerned. So I do think that it's a duty as a judge to actually remind oneself that constitution must always be at the back of your mind. And any matter that you deal with, you have to see how you can apply the constitution in coming to a just outcome.
And one of the funny things, I'm sorry, Chief Justice, I know you've cautioned us against this. One of the odd things is that the appeal in front of you was an appeal against the Land Claims Court, which didn't apply the Constitution.
Yes, and there was a very long judgment from the Land Claims Court. It took some time to actually sift, and yes, it was one of those matters.
Afternoon.
Good afternoon, Ms. Steinberg.
I want to follow up on that. The GCB points out in their evaluation of you that you quietly developed the common law in many areas. And every time you've done so, you've come to the aid of the vulnerable group in that case. And that includes the certification of the class in the silicosis case. And there is the Esther case. There's also in domestic violence, and you'd harmonized concepts of abuse and harm in a way that can only help victims of domestic abuse. And then again in family law, in the Goss case.
Yes, that was a very interesting one.
It really is, and very challenging one, where the court was asked to evolve the common law to recognize jurisdiction over foreign peregrine, where dictal citations been granted and executed. And again, that comes to the aid of the party in a marriage who could end up dispossessed of property that should be hers or his. So it's really to commend you.
Thank you, Ms.
In the work you're doing in fulfilling the promise of the Constitution.
Thank you. Thank you for that.
Commissioner Hassan?
Thank you, CJ. Judge Mandela, I'm over here, Commissioner Hassan.
Good afternoon.
Afternoon. My question is around some element of judicial philosophy, but in particular, your record shows both courage and restraint from the class action work that was done in the Kabwe case, but also in Gala, and obviously, I think it was mentioned, the silicosis cases as well, but also to your precise commercial and tax judgments. The SCA often has to walk a very fine line between consistency and some element sometimes required of innovation. And it must preserve some sort of coherence while advancing the transformation project of the judiciary more broadly. I'm just interested, firstly, to understand what you think or how you understand that balance that's between that consistency and coherence, but of course, innovation, transformation.
I think it's a long question. I'm just trying to think about my own path thus far. And I think as a judge, one has a duty to actually interpret the law, but only as far as the papers allow you. So sometimes the papers allow you to go a little bit broader. Like for instance, in the Goss versus Modlin matter, it allowed me to open the way for further development of the common law. And I'm very excited to see what's going to happen to that matter, because before me, that was an exception. But on the other hand, in Nkala, in the silicosis matter, although I agreed with everything, I penned a very short dissent on the transmissibility of damages. And the reason why I did that was because that specific case was not argued before us. It was not argued that transmissibility of damages should be extended to all claims. It was argued that it should be done in class actions, as one can see from Australia and in Canada. So when the majority then decided to develop the common law to also include all claims, even road accident fund claims, I had to step in and say, listen, let's see what is in front of us, look at the consequences. So I think there's a fine balance. And sometimes, as judges, you've got a pet hate, or you've got something that you've been carrying along for a long time and you want to change it. But it's like putting a round pin in a square hole. Sometimes you have to wait for the right facts so that you can do justice, and then you can develop the common law. So I think it's a fine line that one has to walk.
Thank you. My next question's regarding some of your tax judgments, in particular the SARS versus AXA case, where you emphasized, clarity, fairness, procedural discipline. But tax law often sits at this intersection of technicalities and constitutional principle. And so my question is, how should our courts ensure that tax adjudication remains both legally certain and substantively just, but particularly where more complex statutory schemes affect fairness to taxpayers and the public purse alike?
The matter that I've penned in AXA versus SARS dealt with an objection. So it was very procedural. So it was about whether one can amend an objection at a later stage. And if you look at the judgment, what I did is to look at the pre-litigation phase compared to the after litigation phase. And because there's no rule that provide for the amendment of the objection, one had to go back to the uniform rules of court and then apply that. Infusing constitutional principles, yes, that is a difficult one. I cannot think in that matter specifically how one would principles. I think maybe fairness would be something that one would consider. But in that specific matter, it wasn't applicable and it didn't come up.
The President. Yes, thank you very much, Chief Justice. I didn't want to interrupt the flow of questions, so I didn't speak after Commissioner Marume Wahai had posed some questions, but I think it's important that I should at this platform just clarify in terms of some of the matters that he touched on in relation to the rules of the SCA and the record and so forth. Just to say that the manner in which the record must be prepared is set out in Rule 8. And we require strict compliance with Rule 8. But as correctly pointed out by Judge Windel, there are exceptions that we make when the parties that are involved are unrepresented litigants. And to the extent that there may be a lacuna in the rules, we issue practice directives. And when we issue practice directives, in each practice directive that is issued, you will see there will be a statement that says that if there are any issues regarding the practical application of what is stated in the practice directive, then members of the profession are free to contact the president to raise it with the president. I know that there is a practice directive that was issued by you, Chief Justice, while you were the president in relation to 17.2F applications. It continues to apply, and so far no issues have been raised by any member of the profession regarding regarding the processes that are laid out in there. And we have meetings with members of the profession from time to time. We had a meeting with external stakeholders during the recess, I think it was in July. And that is the platform where we also allow members of the profession to exhale and bring to our attention any issues that they have in relation to how we do certain things. We gave them our side of the story regarding our observation in relation to non-compliance with the rules, and we gave them the opportunity to also raise issues with us, and so far nothing was raised. So perhaps you could write and inquire about the next stakeholder meeting that we will have. The intention is to have it during the recess. So the next one will probably be in January or February. Thank you, Chief Justice.
Thank you, President. No further questions then. Oh, yes, JP?
Thank you, Chief Justice, and good afternoon, Judge.
Good afternoon, Judge President Laleti.
Yes, thank you. I just want to establish, have you ever experienced any challenges of collegiality at the court, at the SCA, such as intolerance to dissenting or somehow bullying, if there is such a thing, intellectual bullying, if there is such a thing, or any other form of ill treatment by the colleagues there? Thank you.
I personally have not experienced any uncomfortability or intellectual bullying. I've certainly enjoyed my time there, got along with everybody. So I've not had any challenges. Thank you for that.
Commissioner Pillay?
Thank you, Chief Justice. Good afternoon, Judge Windel.
Good afternoon, Ms. Pillay.
Judge Windel, I just wanted to raise with you your judgment in Kabwe, where you reached a very difficult decision, which was to dismiss the application for certification. But you do so in such a thoroughly reasoned manner, which I think is highly commendable. Let me start there.
Thank you.
The one difficulty, not difficulty, but question that I had was around the cost order that you
I can't remember.
So what you did is that you dismissed the application with costs, but you did so because you said the applicants had obtained insurance to cover the costs.
Yes.
And you said that because neither the applicants nor their lawyers nor their funders would be liable for costs because they had obtained this insurance, you felt that it was appropriate to grant the cost order. The question I had was, in that instance, what would be the motive? Why would parties then be motivated to get the insurance? If without the insurance, a court would say, well, neither you nor your lawyers nor your funders would have to pay. What would be the incentive for getting insurance?
I regret that I haven't looked at that aspect at all. I know it's coming up at the SCA now in the fourth term. I can just tell you that matter, I would be lying on my back in my backyard and look at the stars at 12 o'clock at night and think, how am I going to do this? It was a very, very difficult judgment. And I remember that the cost was one of the aspects. And I know that there were many reasons why I actually decided to grant cost, because normally one wouldn't, I know. But because we had funders, third-party funders in this matter, and we are talking here about billions of rands, not millions of rands, billions of rands. I can't, unfortunately, Ms. Pillay, I can't remember my reasoning, but I can tell you that I struggled, and I really had to think about that, and I can't remember now what my reasons were. Just thinking out loud, I remember there was lots of money, and because it's not the applicants themselves that are bearing the cost, but the third-party litigators, which actually are making a lot of money out of class actions. That was one of the reasons. I regret that I can't remember, and I can't tell you the reasons now.
I accept that judgment, Nell, and that what you've said now was really what gave me a moment of pause when I was reading your judgment, is because we're entering a space where you have more and more third-party funding looming its head. And in this instance, you said because they had gotten insurance, that was one of the reasons you granted the cost order.
Thank you for reminding me.
But I mean, it says a lot that out of this very long and comprehensive judgment, that's the one issue that stood out, me wanting to raise it. Thank you.
You know, it was like expecting a baby, and I was lying there and thinking, this baby must come out. I can't keep this baby in any longer. But you know, it's such a that was a very difficult matter.
Thank you.
Thank you.
Commissioner Mangen.
Thank you, Chief Justice. Good
evening.
Is it evening already? Yes. Judge Winner, I wanted to ask you a question in relation to the insolvency law. We are living in times where the courts are inundated with litigation, and it's encouraging litigants to mediate disputes.
Yes.
And in the process of mediation, it may so happen that a debtor enters into an agreement with the creditor. Will, in those circumstances, be acceptable to regard the settlement agreement entered into during the mediation process as an act of insolvency in the event that the debtor, for one reason or the other, breaches the settlement agreement?
Well, it will depend on the facts, obviously. So, say, for example, you owe me 10 million rand, and you promise to pay me back at 1 million rand a month, and you fail to do so. And one of the avenues would be then to apply for your sequestration. And obviously, when you've entered into a settlement agreement, even though it was part of the mediation, it's not a privileged document. It will obviously depend on the terms of the settlement. But I can see an example or a case where one would then approach the court and say, this person has acknowledged that he can't pay the debt, that he owes this money, because that would be one of the requirements, and he has now failed to do so. But there are many other factors that would come into play. But I can't see how one would be prohibited from using a settlement agreement. It will obviously, you know, it might be that when one enters that settlement agreement, that there's provision made for the fact that this would be a privileged document. I'm just now thinking out loud. But I've had matters where people have signed acknowledgement of debts, for example, and then they fail to comply with the acknowledgement of debt. And that very acknowledgement of debt is then used as a reason to approach the insolvency court.
Now, let me leave it at there. The professor will take it up.
See, now my nose starts running again.
Do you really want to answer the question?
I'm done, CJ. But the professor is dying.
Is it absolutely necessary? Will it make any difference? This candidate we've interviewed before and tested. All right. Judge Windel, thank you very much for making the time to join us this evening. And thank you for not giving up on us and coming back again.
Thank you, Judge Meyer, and thank you to all the commissioners. I was almost taking out all the books. I'm just taking my own. Thank you very much.
Thank you.